had said that it will appear as adjourned motion, my lord. Extension of interim orders, they are appearing as item numbers 2, 6 and 7 of your lordship's
This list. Yes.
So now I was told that your lordship will be taking up those assigned part-heard matters in the appellate side first.
Don't worry, I will take up. Don't worry, wait.
My lord,
First, I will follow the original side list, then assign part-heard subsequently.
but your lordship is taking up the...
Wait. First appellate side, I will take up from the list then. Yes. Take the microphone.
Original side matter, but then I have to come back, my lord.
Listed matter.
No, it's not listed. The interim order is expiring today. It was moved undefended, my lord, ex parte. My lord, we have served them again, my lord.
No, but then it should have been mentioned.
It should have been, my lord. I also told my advocate on record, may I only pray for this, my lord? May it appear on Monday? I'll give them another notice that this will appear.
Monday, yes. To be mentioned.
Just that, my lord, it's expiring today, my lord. That's the only.
What to do?
It should have been, my lord. Or, my lord, one supplementary list if it can.
If this is the practice, then I cannot control, sir. Everybody will forget conveniently and come and say supplementary.
I'll come back Monday then. I don't have a, my lord, option.
Monday.
Because it was returnable also today. It's not there in the list. The, my lord.
Returnable chilo kina dekho.
Kindly takes the last page, internal page 4. Paragraph 12, list the matter on 7th November. My lord, we thought it would be there, my lord. Maybe because of the change in return.
চেকলিস্ট ফেকলিস্ট বুঝি না, থাকলে পরে আসবে না কেন, এই তো সোজা কথা। চেকলিস্ট ফেকলিস্ট আমি বুঝি না। সাপ্লিমেন্টারি লিস্ট করে দাও আজকে।
But I'll give them another notice at 2 p.m. supplementary list.
Great. To be mentioned just for extension.
Grateful, my lord. I'll put them on notice, my lord.
May I have my lord's
take microphone.
My lord, may I have my lord's list to my lord's leave to mention a matter, my lord. My lord, here, my lord, the matter was returnable.
Louder.
I'm sorry, my lord. My lord, may I have my lord's leave to mention a matter, my lord, which was appearing in my lord's list yesterday, my lord. It was made returnable yesterday by my lord, the coordinate bench. My lord, the interim order had expired yesterday. Yesterday, my lord, I tried to mention at the time of rise.
The list.
Not today, my lord. It was there yesterday. Today,
so it was. So আজকে লিস্টে নেই কেন তাহলে?
It's not in the list today, my lord.
Under which it appeared?
It was appearing under the heading adjourn motion under my lord's original side commercial list, my lord.
দেখি গতকালের লিস্ট।
My lord, we'll see the.
এই মামলা আমি ছুঁতে পারিনি গতকাল, সেই মামলা তো আজকে থাকবে লিস্টে।
The order also.
Wait. কত নম্বর আইটেম ছিল?
27, 28 and 29.
তিনটে মামলা লিস্টে নেই।
The interlocutory application the same suit. Yes.
এই তো। কিন্তু গতকালের লিস্টটা তো বলেছিলাম থাকবে, ধরো আজকের লিস্টে যেগুলো আমি ছুঁতে পারবো না, বলেছি আমি, ঠিক আছে বুঝে নাও। ধরো আজকের লিস্টে যে মামলা আছে সেই মামলাটাও পরের দিনের লিস্টে যাবে, ঠিক আছে? তার ছাড়া রিটার্নেবল যা থাকবে থাকবে।
My only difficulty, my lord, is my interim order expired yesterday. 6 November, my lord, the interim order was there.
Why you have not mentioned? No, in the morning yesterday or
completely
even at 2 o'clock yesterday.
My lord, yesterday at 4 o'clock we came at the time.
It was not 4 o'clock. It was beyond 4:30.
We were waiting.
When I rose.
Of course.
So that was not the time you should have mentioned.
We should have.
Brought
It's
it to my
completely
notice.
our. It's
এটাকে supplementary list করে দিয়ে দাও।
Deeply obliged.
Give notice to other side.
He's here also, my lord.
Online. I am online, lordship. I am online, lordship. Tanuj Gupta in this matter.
Come at 2 o'clock. It will be listed.
Lordship, there is a regular matter that is coming at 2 o'clock. So can it be posted at 3:30?
I am fixing it at 2 o'clock. It will appear at supplementary list. I will extend the interim order.
Okay, lordship.
Okay.
Obliged, lordship.
দেখি এই বইগুলো কে গিয়ে দাও। ঠিক আছে চল।
My lord's kind leave to mention, my lord, for extension of the interim order, my lord.
When expiring?
12th of November, my lord. On Wednesday, my lord.
Means?
12th of November of this
Wednesday.
Wednesday, my lord.
It will be expiring on
Wednesday,
Wednesday.
my lord.
Returnable when?
But on 13th of November, my lord. The time has also been fixed, my lord, at 3:45 p.m. my lord.
3:45 forget.
Yes, my lord.
12th it is expiring.
Yes, my lord.
And it is made returnable in
13th of November, my lord.
13th
Just the
of
next day, my
November. 12th November to be mentioned. 12th November to be mentioned.
lord. Grateful, my lord.
Forget about the time. 12th November to be mentioned.
Grateful.
ডাকো 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 কেউ আছে? Yes,
Your Lordship.
content for the first time
Yes, first time, Your Lordship.
from my order.
Yes, Your Lordship.
Order dated. লেখো লেখো লেখো.
My lord, I am for the respondent, my lord.
Huh?
I am for the respondent. My lord, notice has not been served, my lord, as I.
No question of notice. It's a content appearing for the first time.
First
Yes,
time.
yes, my lord.
So notice.
We
Yes.
require our
Why
compliance.
don't
my lord.
you? Why will you not comply?
But it is
They
been compliant.
not complied here. They have never issued any notice as per this order.
No, no, my lord, it has been issued.
No,
I
no,
have an
no
administrative
notice.
of
No
the-
Come
notice.
on the next day. Come on the next day. Ashun. This is an application for contempt from an order. This contempt proceeding arose from an order dated
27th February 2025.
February 27, 2025. আচ্ছা মাথার উপর হচ্ছে MS Anjali Nag, learned senior advocate, appears for the petitioner. Mr.
Rakesh Kumar, my lord.
Huh?
Rakesh Kumar.
Atish
Rakesh.
Kumar.
Kumar. Mr. Rakesh Kumar, learned counsel, appears for the alleged contemner. How many contemner?
In the sole.
No, sole contemner.
Alleged contemner. তারপর কি লিখেছেন? 27/20/25 paragraph. Today is the first day. Paragraph. The petitioner shall serve notice upon the alleged contemner along with a copy of today's order, and the petitioner shall serve a copy of the contempt application along with a copy of today's order upon the alleged contemner, and shall file an affidavit of service on the returnable day. Full stop. The matter stands returnable under the heading contempt application on December 19, 2025.
Your Lordship.
Obliged.
Obliged, Lordship.
Paragraph. Pendency of this contempt proceeding shall not preclude the alleged contemner to comply with the direction of this court and to file a compliance report on the next day.
Your Lordship. Deeply obliged,
Yes,
Lordship.
Paragraph. In the event the direction of this court is not complied with, comma, this court may proceed to issue rule on the next day.
Your Lordship. Obliged, Lordship.
Not my submission will record not that it has been complied with.
Next. File a report on the next day.
Yes, yes, sir.
Deeply obliged.
Hey. Yes, next. এই লিস্টটা কোথায় গেল? কোড প্লেয়ারের নিয়ে নিই তো? হ্যাঁ, চলো। Yes.
My lord,
open top.
I'm appearing for the petitioner, my lord. My lord, I have duly served. This is my affidavit of service, my lord.
Show me the urgency pleading
Well-
from your writ petition.
My lord, it has been pleaded in paragraph number 30,
30.
my lord.
Read what have you pleaded.
My lord, it is submitted that there is a grave urgency in the adjudication of the present writ petition as the counseling process of the West Bengal Medical Counseling for academic year 25-26 is underway and is continuing and may come to an end soon. My lord, it's ending on 8th of
When
November.
it will end?
My lord, 8th of November. The third round of counseling will end on this Saturday.
Saturday?
My lord,
Yes. What is the matter about?
my lord, the
একটা paragraph মাথায়. Upon urgency pleaded. And since the regular determination has been assigned before this court, comma, this writ petition has been taken up for consideration. ঠিক আছে, বসুন। Yes,
may I state the
আপনার
fact,
নাম
my lord?
দিয়ে দেবেন, বিকে। Yes, 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 yes.
May I state the facts, my lord? My lord, this petitioner is an aspiring medical student. In order to study his MBBS course, he has appeared in NEET undergraduate 2025 examination, my lord. He has passed in the examination, and after passing the examination,
This
my
is a
lord,
question of passing.
my lord,
Serious is
he got the rank card and he has qualified. He has a score card and he even got allotment, my lord.
has he or she,
My lord, my lord.
has she been called for counseling?
My lord, was called for counseling. She has submitted all the documents. Her document was verified. She submitted the fees for participating in the counseling. In the round 1 of the counseling, my lord, if I may say, my lord, there are 3 rounds in the counseling, round 1, round 2, round 3.
Then what
And
happened?
my lord, in the first round, she was not allotted any college. My lord, thereafter, she participated in the second round of counseling. For participating in the second round of counseling, she was not required to pay any additional fee for participating in that particular round. In the second round, she was allotted a medical college, my lord, but in the second, while participating, she has also opted for that option to avail better college. She wants to participate in the subsequent round of counseling even. My lord, for that, she had even participated after getting allotment. She had also participated in the third round of counseling. But inadvertently, she had failed to pay the counseling fees of 2000. My lord, she was not required to pay the fees in the second round. So she was under the impression she was not even required to pay the additional fees of 2000 for participating in the third round of counseling that she inadvertently missed. My lord, because of which her name,
আস্তে আস্তে বাবা।
because of which her name is not appearing in the verified candidate list of the third round of counseling. My lord, the third round of counseling, the results were published on the first verified list was published on 31st of October, and thereafter the seats were allotted day before yesterday on 5th of November. My lord, the third round of counseling is almost going to be over by the coming Saturday, and the straight round will start from Monday. 10th of October, 10th of November. My lord, she wants to participate in the second subsequent straight round of counseling upon payment of whatever necessary fees, whatever is
Yes,
required.
who
My
is
lord,
for the
it's an innocuous prayer.
My lord, I am for the National Medical Commission, my lord. I am for the National Medical Commission. Mr. Nag is for appropriate, my lord.
Yes, what is your instruction?
Difficulty is, my lord, if my lord takes up the,
Come on, tell me.
she has missed the bus. My lord, the point is from round 1 to
Take the microphone properly. Yes.
my lord, from round 1 to round 2, if a person requires a upgradation, then there is no payment of fees. For round 2 to round 3, when an upgradation is required, my lord, they have to pay a particular fees, and then only the name will appear in the eligible list. The eligible list has been published on 31st of October.
Oh, that third round is over.
Third round counseling is over.
Eligible list has been published.
Eligible list has been published. The choice fillings are over. First day of admission is over. While we
Now,
are
can she
addressing
take
the
admission in this college where she was selected in the second round?
difficulty, my lord, is the moment a person applies for the third round, he or she surrenders the second round seat. That is already gone. I have taken instruction. In all probability, it has been filled up. It is because of our negligence. We cannot, and the entire thing is a national digital mechanism. We cannot enter into it. We have no powers.
Only inadvertent error on the part of the
What inadvertent, sir? All over India, counseling is going on.
my lord. I
You
was
cannot keep or the information when you are participating in the third round. you deem to have, it is a dim knowledge of your client that what are the terms and conditions for participation.
My lord, my lord, I was required to pay a fee of 2,000 which I did not pay. But other than that, all the necessary formalities were
Doesn't
done, my lord.
matter. Doesn't matter. The entire list is published now. I cannot disturb that.
My lord, I'm the third round of counseling is over. My lord, I'm now my innocuous
Can
bail
she participate
for the next
in that
round.
stray one?
My lord, it is a continuous process. It is a continuous process. Once you are out of the, my lord, it is
Track.
like a pyramid. You take
Once you are out of the track.
Yes. I am sympathetic, but I have no power. Because, my lord, allowing her will be allowing the entire process to be stalled, put her inside, and change the schedule, which is beyond my.
If you take the entire schedule, let's say 50 candidates are there participating in the stray round.
Correct.
Can she be allowed as 51st candidate?
But then she will not get anything. It will only be for the sake of joining.
My lord,
Her rank will go down. If what Milord is suggesting,
Doesn't matter.
that means she will not get anything.
No, but any college in West Bengal.
But that is to we don't know. That is to be is beyond us because it is a digital mechanism. Which college she will get, we even cannot apprehend.
Doesn't matter. Wherever, whichever.
She might not get anything. We have to take instruction what has fallen from my lord specifically. I do not know, my lord, because this is
according to inter-se merit of the candidates participating in the counseling.
Help her. How to help her? Tell me.
According to inter-se merit of the candidates
How to save her?
Participating.
একটা candidate ভাই NEET qualify করে medical এ chance পেয়েছে.
But the moment we got it, at least from the moment I got the brief.
Come on, tell me how to how she can be saved.
Can this be passed over for some time?
Move it to Monday before the regular bench.
My lord, the stray round of counseling commence from Monday, my lord. My lord, the stray round
registration will commence.
Registration
for participation in stray round will commence from Monday.
My lord, if my lord takes
registration will commence.
My lord, if my lord takes up page number 43 of the petition once.
1 second.
I have just asked my junior to take instruction whether stray round can be allowed.
Stray round can be allowed or anywhere anywhere in West Bengal, wherever.
Without counseling, it is not permissible.
No. If she is allowed for counseling, then wherever she gets. I will not have any sympathy for that. But only sympathy if she gets.
If we can technically allow her for this stray round, I have just asked my junior to take instruction.
Well, I am not.
You go and take instruction. I'm waiting. Ask your client to be sympathetic. The court is full of sympathy. Tell him.
But if your lordships kindly turns to page 43, my lord, being an officer of the court, it is my duty. Page 43 of the writ petition. 43?
43.
Yes.
My lord, serial number 9.
Serial number 9.
My lord,
yes.
It's online stray round. Online registration by the candidate qualified through the NEET UG 2025. Next column. Online fees payment. So he can, my lord, if your lordships permit.
My lord, for appearing in the straight round of the counseling, I need to again pay the fees which I will pay
please,
and I need to register, my lord.
Please, let us think over it. Enough. Your client has shown enough competence. Ashu. Let him come. Let me record the fact. The petitioner is an aspirant for NEET.
NEET UG 2025.
UG 2020-25 examination.
Aspirant of taking admission in MBBS course.
My lord, she is a aspiring medical student.
Completed NEET UG. Already completed. Oh, yes, my lord, sorry.
Examination. She has reached. Please. She has reached up to the stage of counseling. Post up. In the first round of counseling, since she did not get the medical college of her choice, she opted for the second round. Please, both of you kindly hear me. second round. Where no fees were required to be paid, Since in the second counseling also, she did not get a college of her choice. She opted for third counseling.
Second round of counsel, first and second, my lord, one fee, only one fee in first round.
I said that.
Yes.
That's why I say.
Did not get second round. She was allotted. She wanted
Please,
third.
please listen to me. That's why I'm saying. Both of you were talking.
Sorry, my lord.
কি বলেছি? না, first round she did not get. কি বললাম পড়ুন। একটু আগের থেকে পড়ুন। Full stop. In the first round of cartoon, সব কেটে দিন. In the first round of counseling, she was not allotted any medical college. So, so she participated in the second round of counseling. For full stop. For participating in the second round of counseling, there was no requirement of payment of fees. Full stop. In the second round of counseling, the particular college she was allotted with, since the same was not of her choice, she opted for third round of counseling. Paragraph. Learned counsel appearing for the petitioner submits that the petitioner was not aware of the fact that in the third round of counseling, necessary fees was to be put in. And only then she was to be permitted to participate in the third round of counseling. It is also submitted that since there was no requirement of paying fees in the second round of counseling where she has already participated, she was under a bona fide impression that no payment of fees is also required to participate in the third round of counseling. Paragraph. Since she has not put in the necessary fees for third round of counseling, she has missed her chance. However, the online stray round of counseling is fixed on November 10, 2025 upon payment of online fees. Yes, sir. Now you tell me.
Stay round of counseling is only for people, my lord, who are not allotted any seat in 1, 2, 3. She is a allotted candidate, not reported.
So, would you allow her to get his allotted seat?
I don't have the power to allow. This is about a policy, my lord, which covers the entire country, the entire country's admission. If we make an exception here, this will open floodgates. Because there will be candidates who will be getting allotted seats in different rounds, but would like to try their luck in the stray round. We are sympathetic, my lord, but perhaps we cannot.
If I allow her to participate in the stray round as the last candidate, then what will happen?
As the last candidate, my lord, this will mean that her rank will go. Then, with all humility, my lord, allowing her, not allowing her will be... Allowing her or not allowing her will be a futile exercise. Because she will become the last candidate. Maybe 10 lakh, maybe 12 lakh she will become.
My lord, if I may... My lord, if I may submit, my lord. My lord, in the third round of, while participating in the third round of counseling, she had already let go her. My lord, this process has been framed just to prevent wastage of seat, my lord. My lord, while participating in the third round of counseling, I have already let go the seat which was allotted in the second round of counseling. My lord, I was allowed to participate in the third round of counseling only because of the fact, because I did not pay the fee, my name did not appear, my lord. My lord, nothing in the
So
information.
the moment your name did not appear, you're out of the queue.
My lord, there's nothing in the information bulletin which states that I will be prevented.
Sir, for one candidate, the entire process cannot be upset.
My lord, kindly, if my lord kindly goes through the information bulletin which I have annexed with the writ petition, my lord, there's nothing in the information bulletin which is followed for this entire counseling process which says that I cannot participate in the online stray round of counseling, my lord. My lord, if I have the merit, I will be allotted any college. My lord, simply I want to participate in the counseling process as per the norms, my lord.
There are notifications.
As per the norms, you are not entitled.
My
That's
lord,
what they're saying.
my lord,
Because you have not. Because what is the for whom stray counseling is held?
My lord, if
Those who have already participated in the third counseling.
my lord, if my lord takes a
Right?
petition,
And not
Yes,
allotted
yes.
any seat in
My-
any of the
In
county.
any of the counseling. Tale?
my lord, after allotment, I did not report. That seat I did not
That's
choose,
not,
my lord.
that does not mean.
My lord, if my lord
My lord,
kindly
may
takes a
I
page.
clear the air? I appear for the state. It has just been submitted by the petitioner that he did not report. That means, my lord, that has been clearly mentioned in the information.
Sir,
bulletin.
come to a solution. If you
Yes.
can give any solution, tell me.
Because
he has chosen to annex the information bulletin. He has not chosen to annex the notifications which says stray round is only for the non-allotted candidates.
Even
It is
in
his
the-
choice.
My lord,
He
is
cannot take a guard behind that.
The petitioner.
my lord kindly
in-
see
in-
page
in the
29, my lord.
comma, the petitioner prays for a chance to participate in the stray round of counseling upon payment of online fees. Paragraph. Mr. What is your name?
Orko Kumar Nag. Orko Kumar Nag.
Mr. Orko Kumar Nag, Learned Counsel, appearing for
WBMCC, West Bengal Medical Counseling Committee.
West Bengal Medical Council.
Counseling Committee.
Counseling, West Bengal Medical Counseling Committee. Stroke respondent numbers.
3 minutes.
Respondent number?
3.
3. Submits that the stray round of counseling is meant for those who have not been allotted any seat throughout the 3 stages of count. কিছুতেই শুনবে না নিজেরা ওখানে।
Lord, I am, yeah.
Please listen to me. কি বললাম? কি বললাম? That the stray round of counseling is meant for those who have not been allotted any seat throughout the said 3 counseling stages. Full stop. Since the petitioner had already been allotted one seat in the second round of counseling, the petitioner is not qualified to participate in the stray round of counseling. And the petitioner has already missed her chance. Full stop. To allow the petitioner, full stop at 4, to allow the petitioner in the stray round of counseling will have a cascading effect on the selection process, which is not permitted in law. Yes, Mr. Shunit Rai, Learned Counsel, appears for
My lord, National Medical Commission.
National Medical Council
Commission.
National Medical Commission, stroke, respondent number
7.
7.
Hmm.
You have anything to say?
No, my lord.
Mr.
Vivekananda Bose. Vivekananda Bose.
Vivekananda Bose, Learned Counsel, appears for the state. / respondent number 1.
I appear for the university. Respondent number 5 and 6.
Mr. Your name? Oshim? Osham? Write down. Osham Dipto Sannal, Learned Advocate, appears for Respondent number 5 and 6. After considering the submissions made on behalf of the parties and on perusal of the writ petition, it appears to this court that since the petitioner was allotted a seat in the second round of counseling, but ultimately failed to take part in the selection process, which is otherwise a rigorous procedure. If the petitioner, if the petitioner is straightway allowed to get a seat in any medical college, this may disturb the entire selection process, which cannot be done.
My lord, if I may say, it's an innocuous prayer, my lord. I simply want to participate in the
At the same time,
selection process, my lord. It will not
paragraph.
compromise with the merit.
This court, in exercising its power in equity, can stretch its arm a little bit. Full stop. Paragraph. The petitioner shall be allowed to pay online course fees and shall be allowed to participate in the stray round of counseling as the last candidate of the entire list. However, if ultimately, after completion of the entire selection process, any vacancy is available which is not filled up within the scheduled date, then the appropriate authority shall consider the case of the petitioner's admission in any college, in any medical college, wherever it is situated, within the scope of the entrance examination. Paragraph. However, it is also made clear that this order shall not create any right or equity in favor of the petitioner. And the petitioner shall not claim any right on the basis of this order in future, in any manner whatsoever. Full stop. The allotment of the petitioner shall be purely at the discretion of the authority if ultimately vacancy is available. And if ultimately vacancy is available. Full stop. Paragraph. This order shall not be treated as a precedence. Yes. If ultimately vacancy is available, then you place. If no vacancy, she will not be placed. And this order shall not be treated as a precedence. With the above observations and directions, direction likh now. This writ petition bold WPA 25140 of 2025 stands disposed of, comma, without any order as to costs. Yes.
Next one is same.
It's a similar matter, my lord. Only one, for my satisfaction, only one page I want to show, my lord, from the information bulletin, my lord, which says about the online stay round, my lord.
Sir, it will not create any right.
My lord,
If
if my
you are
lord,
happy with this type of order,
my lord, for my satisfaction, only one paragraph, my lord.
even then, yes. I will not disturb the selection process. Show me which page.
My lord, page number 29, my lord. Service.
Yes.
My lord, it says, my lord, this entire information bulletin says how the entire counseling process will take place, my lord, and how the examination will be conducted. My lord, it says for the online stay vacancy round counseling, the opportunity for fresh registration both for new coming candidates. The new coming candidates can
Yes,
also register.
Newcoming means those who have not been
Not
allotted.
those who have not.
If you are satisfied with this order, then I will pass
my-
or I will simply dismiss.
My lord, if I may read, my lord, for my satisfaction once, my lord.
Sir, I will not disturb the selection process.
My lord, the
Very well, you move before the regular bench. Others.
my lord, I totally bow down, my lord.
Before the
lord,
regular bench.
My lord, I totally bow down by the order.
The same.
Similar.
What changes will be there?
Similar. It's a he. The candidate is a
Candidate টাকে he করে দেবেন next ইয়েতে writ petition.
The appearance remains the same except for the state.
You give all serial number and the appearances. এটা he হয়ে যাবে। পরেরটা লিখুন। এটা কোনটা হলো? WPA, this is
25141.
এটা he হয়ে যাবে। ঠিক আছে? আর next one only দুটোই আছে।
My lord, 25140 and 25141. My lord, item number 3 is different, my lord. The facts are entirely different for item number 3.
Oh, 3 is different.
My lord, different.
All right. What is 3?
My lord, I am being led by Mr. Kormokar in this matter. He is appearing virtually.
Yes. Come on, tell me.
My lord, he is appearing virtually, my lord.
Are you start placing? How does it matter?
My lord, the petitioner has briefed a senior, my lord.
Am I audible to you?
Yes.
Your lordship has
Show me the urgency first. Show me the urgency.
is the urgency, my lord.
You are not
Same
audible properly. Show me the urgency. Which page? Which paragraph? Mr. Counsel in court.
My lord.
Which paragraph? Which paragraph is the
Paragraph
urgency?
36. Paragraph 36 of the petition, my lord.
Yes, what has happened?
Yes, my lord, here, my lord, the counseling, my lord, your lordship has seen is on, my lord, closing on this Saturday, my lord, that is tomorrow. Now, my lord, I was given a chance, my lord, to convert my OBC candidature into, my lord, NRI sponsored candidature. My lord, I applied. Unfortunately, the time span granted, my lord, the time span granted was, my lord, within the holidays. My lord, that is, my lord,
Doesn't matter to you.
my lord,
Doesn't matter to you.
Lord, unfortunately, I had to obtain a certificate from the BLRO. The BLRO office was closed.
I will not.
That's why, Lord, I tell your lordship, Lord, what's the difficulty?
Show me when you were granted this permission for conversion.
Yes, Lord, kindly comes to, Lord, page 45.
Show me.
Kindly, my lord, turns over to page 46.
No, let me see what is
Yes,
the.
yes. It is for the information to all the candidates that in compliance with such and such, the candidates who want to participate as NRI should submit the following mandatory documents. NEET UG, I have submitted. No difficulty.
You show me that you are allowed to participate as NRI.
Yes, Lord, kindly comes to Lord, the problem. I tell you, Lordship, Lord, this is the notification enabling me to participate.
No.
Persons.
No. This is the notification for the exclusive NRI to participate. You show me that you who has participated not as NRI, just you have started your submission with that. You are
Yes.
allowed to be converted and allowed to participate as NRI.
But
So
I participated in the NEET examination under the OBC category.
now you show me OBC to NRI, you are permitted.
Lord, it is by virtue of this, Lord, that I participated, Lord, because the NRI candidature opened in this.
No, NRI candidate is open only who intend to participate since beginning as NRI.
Lord, if that
Not the OBC will be converted.
Subject to correction, Lord, if that would have been the situation, Lord, then there was no requirement for this notification after the second rounds.
Kindly read the notification.
Yes, Lord, kind of candidates who claim to be NRI, OCI, or want to get their nationality converted from Indian to NRI.
Right.
So, Lord, I applied.
At the threshold, one has to apply as NRI. Not applied as OBC, then you did not get chance. You took a chance for conversion as NRI category.
Lord, what I'm trying to impress upon your Lordship is, or want to get their nationality converted from Indian to NRI.
Sponsored by the NRI candidates, my lord. A candidate who is sponsored by a student who is sponsored by NRI candidates, my lord, is treated an NRI person, my lord, treated as NRI candidate.
Correct.
My lord, here, my lord, kindly turns to page.
Now, a OBC participants who has participated as OBC, can he subsequently participate as this candidate?
If he is sponsored by some.
That's a different issue. That is permitted.
Yes, sir.
That is permitted. Very well. Yes.
Now, this is the notification enabling me to do that. Now, four requirements were there. First, your Lordship has seen NEET UG admit card, scorecard given, proof of NRI status such and such given, Lord, affidavit notarized by such and such number 4 given, all other documents all given. The problem was with respect to item serial number 3. Certificate of relationship between the NRI relative and the candidate issued by competent revenue authority through family tree.
Achha, this was 1 second. This was a notification of September.
My lord, 26th of September.
Correct.
26th of September. Kindly turns over. Lord, kindly turns over to page 46 once.
Yes.
My lord will kindly see the time period to deposit, Lord, those documents or submit those documents. 27th of September to 29th of September.
Yes.
So, Lord, I got this notification on 26th, and from 26th was the last working day in our state. So, Lord, none of the...
You have filed your writ petition on 6th of November.
Lord, what I did was, I submitted all these documents along with a panchayat certificate on this within this date. Subsequently, immediately after the reopening,
Panchayat is not the revenue officer.
Immediately after the reopening, Lord, I obtained a certificate from the BLRO.
What reopening?
On 8th of October.
And your writ petition is of 6th of November.
But 6th of November, Lord, I waited because I wanted...
You go before the regular bench.
No, kindly hears me. No, kindly hears me. Kindly. Now, Lord, what I did was I resubmitted that certificate to the authorities. Now, Lord, I was waiting for the publication of the list. That list, my lord, will get at page 125.
Why you are waiting? You know that you have not submitted the revenue authority certificate.
Lord, I submitted subsequently immediate at the first available opportunity. So, my lord, I was expecting that I will get, my lord, my name will surface in that list.
Yes.
Now, my lord, the difficulty is, my lord, this list at 125 was published, your lordship has seen, on 14th of October. And unfortunately, kindly comes to 134.
Sir, at best I can send to an authority for consideration, nothing more than that.
In this matter,
Lord,
my lord,
in the meantime,
Union of India is appropriate authority, my lord. Central Medical Counseling Committee, my lord. If
Who is the
they-
respondent?
My lord, the Central Medical Counseling Committee is a party, my lord. Respondent
Yes.
number 4. Respondent number 4 আছে তো।
Where is he? Where is it?
Medical Counseling Committee.
so that is situated in New Delhi.
So you have to serve and come.
My lord, I have
they
my lord. My lord,
Service is complete.
Show page, show me the page how you have served.
my lord,
I at best can send it for the consideration, nothing more.
In the meantime, Lord, kindly considers page 134 once.
Yes.
Kindly considers page 134 once.
Yes.
My name has surfaced, my lord, in the college that I applied as my lord NRI candidate. The difficulty is, my lord, here what will happen, my lord, kindly comes to 134.
Yes, I
Your
have.
lordship has seen my name is there under NRI quota. Kindly permits me to continue with this, my lord, process till this verification, and the verification the document is already there. It's only because of the peculiar situation, my lord, I could not file it. Nothing more than that.
Yes, so where is the problem if the authority considers you within 1 week?
Lord, kindly permits me to participate in the process of this allotment and the subsequent procedure of 134.
Acha.
In the meantime, so that in the Lord, nobody is prejudiced.
my lord, ultimately, if my lord, the central authority not permit the petitioner to take admission in MBBS, then the seat will be wasted, my lord. Because by that time, my lord, entire counseling process will be over, my lord.
So, ঠিক আছে, he will also participate. His name is already there in the college.
Because he has registered himself in the State Medical Counseling Committee as NRI quota.
Correct.
But not, my lord, it is not, my lord, maintained in the portal, designated portal of MCC Central.
So I'm sending it before which is the authority.
My lord, MCC.
Respondent number?
Respondent number 4 for consideration within specific.
Yes, within 1 week. Within 1 week.
Kindly, my lord, kindly records that the problem that I had faced because of the holiday.
I will say if the decision goes in your favor,
my
then
lord,
college shall consider for your admission.
Within
I'm
the
grateful. Not the only problem. The only problem will be
stipulated by the MC.
What is the cutoff date?
My lord, as per the Supreme Court, my lord,
বন্ধ হয়ে গেল। My lord mute হয়ে গেল। For some reason, Lord, I understand the court audio system is muted. Lord, I am unable to hear, my lord.
by which college? Respondent number? By concerned college, by the concerned college. Then how can I delete the college? College, it's a private college. Private college.
Lord, may I? Lord, the college is not party, I can understand. Lord, the only thing is, Lord, that the process has already begun. This is not going to affect the college in any manner whatsoever. Within 7 days.
The college has to consider afterwards if you succeed before the authority.
But if I succeed, the process automatically follows. Nothing has to change.
Concerned college. Right. Since the petitioner could not produce all the certificate of relationship with the NRI relative issued by the competent revenue authority, as mentioned in the notice dated September 26, 2025, Annexure P5 at page 45 to the petition, before the respondent number 4, the said authority has not considered the candidature of the petitioner as an NRI candidate. Paragraph. Mr. Rahul Kormukar, learned counsel appearing for the petitioner submits that subsequently on when you have produced. On 10th of October. On October 10th.
Page 86, Millard. Page 86.
On
the document is at page 86, 10th of October. I had applied on 8th of October, the reopening.
On October 10, 2025, the petitioner ultimately has produced the said relevant certificate appearing at page 86 to the petition. Before the
and on the same date, I had emailed this document to the authorities.
Before the respondent number 4.
My lord. Great.
Paragraph. In view of the above, upon urgency period, since the regular determination in view of the above, comma, since the name of the petitioner, in view of the above, since the provisional allotment letter has already been issued in favor of the petitioner by the relevant by the respondent number 3. Featuring the name of the relevant college, comma, the petitioner shall forthwith serve a copy of this writ petition upon the respondent number 4 along with a copy of today's order. The respondent number 4 then shall take its decision on the issue by passing a reasonable order in favor of the petitioner. By passing a reasonable order in accordance with law, positively within a period of 1 week from the date of communication of this order. The respondent number 4 shall also communicate its reasoned order to the petitioner, respondent number provisional issued by
3.
Respondent number 3 and the relevant medical college positively within a period of 3 days from the date of the said reasoned order to be passed. The petitioner shall then also communicate the reasoned order, if it goes in favor of the petitioner to the relevant college, who shall take steps in accordance with law. It is made clear that this court has not.
Lord, the public holiday part, my lord, if your lordship would kindly clarify, my lord.
No, I will not clarify anything for them to decide. Sorry, no. You make.
No, in the state of West Bengal, it was a public holiday, my lord. I could not have obtained, my lord. Only that part.
You had time at least 2-3 days. You wasted. You filed the petition after 1 month.
The 26th of September, the notice was issued. 27th onwards, holiday started. Lord, I could not have obtained, my lord, the certificate, my lord.
Sorry, I will not extend. Very well, I'm giving a chance of hearing. You go. If it is delayed, it will be delayed. Up to you. I will not extend. Cut off date. Court, how does it matter with BLR office of court? BLR office October. So how do we आगे की बोलना ना कल एक के दिन एक बार लिखना था While considering the issue, the respondent number 4 shall also consider the public holidays when the office of the revenue officer was also closed. Closed as official holidays, on official holidays, announced by the state. It is made clear that this court has not gone into the merits of the candidature of the petitioner, in the event the reasoned order goes in favor of the petitioner, the relevant college authority shall take steps in accordance with law. It is made clear that this court has not, that this order shall not create any right or equity in favor of the petitioner. If the petitioner is not entitled to right or equity in favor of the petitioner. Full stop. Paragraph, it is clarified that the entire process, including the consideration by the relevant college, must be completed within the cut-off date fixed by the respondent number 4 for admission of the students. Good stuff. Since affidavits are not called for, the allegations made in this writ petition are deemed not to have been admitted by the respondents. Paragraph. With the above observations and directions, this writ petition hold WPA 25142 of 2025 stands disposed of, without any order as to cost.
So
Thank you.
So the respondent authority will dispose of, my lord, within a span of 1 week. That my lord has, my lord, directed, my lord.
So,
Grateful.
thank you.
Obliged, my lord.
I have mentioned that this official holiday will be considered.
Obliged. I'm grateful, my lord. I'm grateful. Obliged.
But the previous 2 cases are really shocking. First two cases. They are really shocking. That's really shocking. Those are really shocking. This one, that is really shocking. Not only that, 6 November is the release day, but I think that those 2 matters are really shocking. All right, let's see. Contempt. কন্টেন্ট গুলো শেষ করে আমরা চলে যাব অরিজিনাল সাইডে। ঠিক আছে, অরিজিনাল সাইডে যেরকম লিস্ট আছে সেইভাবে ফলো করব। চলো, আপনি last preference, sir. First, because my regular determination is the original side. So I have to justice that list first. Madam, question of survey, all matters shall remain in the list. Whenever I will get time, I will. Because I tell you, madam, my primary list is now with the original side list. So I have to justice on that list first. Just because the content can take. And these are the 3 matters urgent determination of Justice Basu. Next. I'm trying as much as, but I don't know what will happen. Of course, with the cooperation of the bar, of course, that is always there. Yes. Come on, content. First time. Take the microphone. Sir, you are for the yes. What is the stage that has not been complied with? Show me. You are for the Pradhan. So you have nothing to do. You have complied your part. Acha. We have no grievance with the Pradhan. Show me the content petition. So now, who is the contender? Pradhan. Only contender. Nothing. Contender has performed his job. Yes, do take steps in accordance with law. You take steps in accordance with law. I cannot expand the scope of the proceeding. Come on. That's up to you. Sir, that does not mean your right goes. The last order dated August 29, 2025 shows that the alleged contender has also filed its compliance report. Rule was issued. Paragraph. Mr. Shomnath Ghosh, Learned Counsel, appearing for the petitioner, submits that insofar as the obligation of the alleged contender is concerned, the direction of this court stands complied with by him. Yeah. Mr. Atreya Chakravorty, Learned Counsel, appears for the alleged contender. In view of the above, nothing further survives in this contempt proceeding. In the event the rest of the direction is not complied with, the petitioner shall take steps in accordance with law. On the pair of Mr. Shomnath Ghosh, Learned Counsel, appearing for the petitioner, no, this is not. Please be there. Please be there. Don't come there, madam. And considering these submissions, if the petitioner is of the view that the other directions in the order, in the subject order, has not been complied by any other authority, the petitioner shall be at liberty to take steps in accordance with. Paragraph. Nothing further survives in this contempt proceeding. Paragraph. Rule board, issued, stands discharged for the board, accordingly, board WP CRC 124 of 2025 stands dropped hold and normal closed hold. Paragraph. The paragraph number both stands disclosed. Next. First time. Ashok. A typical order. Order dated February 13, 2025. Schedule due to paragraph pendency of this contempt proceeding shall not preclude and to the carry out the direction of this court by the alleged contender. How many contenders? Or alleged contender, and file a compliance report on the next day. Paragraph, in the event the court finds non-compliance of its direction, the court may issue rule. Court may proceed to issue rule on the next day. So next. Returnable. Contempt, the matter shall appear under the heading contempt application on January 9, 2025. 2026. 2026. Next, come on. 6. First time. Second time. Doesn't matter. First time, order dated. July 8, 2024, তারপর সব এক আছে, এই একই দিনে দিয়ে দিন, রিটার্নেবল করে দিন January 9. Next. Order dated December 11, 2024. Returnable with same date, 9 January. আর ওই দুটো প্যারাগ্রাফ দিন সব জায়গায় থাকে, আর অ্যাফিডেভিট অফ সার্ভিস থাকবে আর কমপ্লায়েন্স রিপোর্ট থাকবে। নেক্সট। হ্যাঁ, কন্টেম্প শেষ, কমন original side. Thank you. করে দিয়ে দিন। অ্যাডমিশন টপগুলো আছে, বাচ্চাগুলোর অ্যাডমিশন next. Follow the list. I will give preference to the original site list first because that is my primary determination now. Next. Only content I will give preference. Next, no. Next. Preference shall be given to the original site list because that is my primary determination now. Next. Only thing the content I will take up and I have taken up, but only the new content and content motion stage, not the hearing. Yes, I can release, sir. I don't believe in fixing time. Chalo. Fixing time. ডাকো লিস্ট ডাকো, একটু লিখতে তো হবে না, আমায় তো শিখতে হবে বাবা, ডাকো কেউ দেখি। ফার্স্ট টাইম, হ্যাঁ ফার্স্ট টাইম আসুন। None appears for the petitioner nor any accommodation has been sought for. This is a contempt proceeding. Arising from a judgment and order dated May 20, 2025. Today is the first day. Paragraph. The petitioner shall serve a copy of the contempt application along with a copy of today's order upon the alleged contemners. কোথায় আমাদের অডিয়েন্স সাইটে রেকর্ডিং অফিসে কোথায়? হ্যাঁ, তো অ্যাপিলেট সাইট তো নেওয়া হয়ে গেল। হ্যাঁ, আমি পাঠিয়ে দিচ্ছি। চলে যাবে না কেউ, বারণ করে আমার সঙ্গে কথা বলবেন করে। দেখুন একদম লিস্ট ফলো করুন। Item number 2. Application form. Finance expiring. I don't think who mentioned? That's right. So today nobody has mentioned. I don't want to Mohit Shah would have taken it. Nobody is ready. So very well, then let me call the appellate side list. Ex parte I will not take up. Very well. No. Then wait. I'm taking up the motion assigned from the appellate side list. Motion assigned. I'm inform the library. Come on. Motion assigned. Nothing appellate side. না ওরা আসলে হবে না তো ডাকুন লিস্টে দেখে নিন মোশন অ্যাসাইন যদি কেউ না আসে পাস ওভার করে বেরিয়ে যাবো ডাকুন কেউ না এলে পাস ওভার করে দেবো সেটা ক্ষতি করার দরকার নেই Oh, with the original side, I called the list, but nobody was there. So I'm calling the motion assigned. Key matters I have called. So that was I just want to take the motion assigned there from the appellate side. Then I will come back. In the meantime, you inform. Motion assigned. Let me call. If nobody is there, I will pass it over them also. Next. No, your other side. Then that's all right, but acquitted. But where is your other side? Very well, I'm keeping it in the list. Just pass it over. You give notice. It will remain in its position. That, sir, whatever you will write, it's up to it's your business. Next. Where is your other side? Where is the question of admission nowadays? No scope for any interim order. So, Sardat come back. So, no, the order is required. The moment I will pass an order, it will not appear now. It will appear, it will take some time to appear. So, choice is yours. Sir, I am absolutely with all assigned matters, with content, then the heavy list of the original side. So, the mercy which I could have shown on the previous determination, I may not this time. Sir, you Sardan, come back. Let it retain its position. Let it retain its position. I don't mind. Then it will appear after January. Sardan, come back. Next. Same. Sir, it will retain its position. Next Friday, the same list will be published. So just passed over for the day. It will appear again. You serve notice. Passed over. বাহ ছেড়ে দিন এরপর আমাকে অরিজিনাল সাইডে যেতে দিন চল নেক্সট আরেকবার অরিজিনাল সাইড প্রথম থেকে ডাকো কন্টেন্টটা তো আমি অর্ডার করে দিয়েছি নিউ চেম্বার থেকে ডাকো $20 gone is gone next paper application item number 2 I have not done any harm to any matter then it's all right no problem come on the next day come on the next new chamber where is your other side okay who is there what is the matter about yesterday I have delivered one judgment have you considered that কালকে নিউ চেম্বার নিউ অ্যাপ্লিকেশনে যেটা ছিল তার একটা কপি দাও সার্ভার থেকে কাল রাত্রিবেলা সার্ভার করে আমি বাড়ি গেছি 9টার সময় হ্যাঁ বড় জাজমেন্টটা নিউ চেম্বারে ছিল ওই উনি ওই আরেকজন আপনার খলি বাচ্চারি অনেক রাত অব্দি ছিল because yesterday was the either 119th or 120th. That was the day, crucial day. So I allowed the written statement with reasons to file at 6:30. কালকের লিস্টে ছিল বাবা চেম্বার অ্যাপ্লিকেশন এই কোর্স দেখি দেখি বাবা বাবা অ্যাপিয়ারেন্সটা আমায় দেখতে দাও হ্যাঁ 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 এটাই চেম্বার একটা কপি দাও তো আমার সার্ভার কপি you take the number and consider it was also within 120 days but I have to hear him what is the opposition he raises take the number and do it. Read it. Whether it covers your case or not. Beyond 120, I have no jurisdiction. Beyond 120, absolutely I have the power. Who denies? I say that you consider this one, the latest one I have done. If it covers, then nothing to argue further. Yesterday's list, one chamber application was there. So next, fast over. So which one you want to move? All three? Sir, I tell you again, the list is such, I am also very confused. That's why you perhaps noticed the first 2 days I tried to follow the practice, the custom, the practice in terms of the rule. I have given the date-wise classification, when I shall take which. Then till 9:30 I was there, all of us we were there almost at 10 day before yesterday, before the vacation day, Guru Nanak's birthday. We found it is impossible. It's impossible. So, and the interim order is expiring on the returnable date, but the day is not for the chamber day. So I absolutely struck out all this. Because the litigant right must be protected first.
Sometimes they need to be logical on the schedule. If it is correct, it was made that on the internal if you want to risk.
Not only that, yesterday Mr. Judicial chaplain on matter undertaking to be mentioned but fixed for examination. All right. No, first you tell me you are there.
I will not say anything away, but right away, Interim has to pick it up and a point of short time. But again, what has happened,
You proceed. Where is the difficulty? How does it matter? He will come. What is his application in chamber? Proceed. What is the? I will read the plate. If I find it's revocable, I will revoke. If it is not revocable, I revoke. Clause 12 or section 12? Section 12. He is saying that 12A. Not required reading of plain.
What is happening?
No, Mr. Ray, one thing. Good, bad, ugly, indifferent. If such an application is there, revocation of 12A, I have to hear it first. But I agree that once it is if he succeeds, then the entire suit goes, you are also gone. If it does not succeed, automatically your applications will be taken up. Then so very well, I will take up 12A revocation. Now you are opposing the prayer for adjournment. Matter is. Chalo, come on. No, proceed. Proceed. Let it come, till then you proceed.
Suddenly, when they come back to find the property around that period.
When will you proceed?
I am without any security. Because I don't even know assets are
proceed. Place your plane. And send for him. Let us read the plan. Hector background will come. Where is the plan? Which page? Read from the beginning. Read from the first line. I don't mind. Yes. Page 15. Sir, if you can convince your other side, I have no problem to adjourn the matter.
I can concede to the section, but they take another time, they want to file an appeal. You will not harm anyone. I have been asking for this, I am not asking for any minor order to prejudice. But at least there will be one. Then I can.
So proceed with the plan. First, you tell me, give me what is the nature of the claim. Then you place the claim. Second, page. He is Baja. He is claiming price of goods sold and delivered. As simple as that. So why you say 12A is not applicable? original printer नहीं original printer আসছে না কেন জিজ্ঞেস করছি অ্যাপ্লিকেশন গুলো আছে যেমন যদি কলেজ সমস্ত আনতে হবে প্রিন্টেড ফাইল নেবে কারণ দেখছো তো একটা প্রিন্টেড অ্যাপ্লিকেশন একসঙ্গে অ্যাপিয়ার করছে তো প্রিন্টটা থাকা দরকার so many order granting leave order sheet দেখে বের করে দাও give me the order allowing 12-day leave. হ্যাঁ সুপার সেটা রাখছি প্রিন্টেড ফাইল তো বড় আচ্ছা ঠিক আছে থাকা থাক পরে let's read the order first. Take the order. Place the order. Perfect. Yes, yes. Wait. The plaintiff is supplying to show now the plaintiff has come. You kindly show me the supporting pleading from the plaintiff and the documents. Your junior is here? No, yes. Which paragraph? Paragraph 5 first. No, you show me that what is their amendments in support of this sentence. 1-3. Paragraph 30. March 12. Oh yes, but you're doing very good. So your junior prayed for, but he is opposed on the ground that he has some urgency on the later two applications. Then I said that when the development is pending, I will take up that first. Paragraph 12. Yes, sir. One second, sir. Little slow. Yes, further it was informed. Page, let's say read. Page 157. Yes. I come, first read, complete the paragraph. The said email. Next. Place it, place it. No, 157 first. That's the supporting document. So place it. Hey, volume 2 now. $157. Yes. Date of the meeting. Ayush is different. Ayush notified the cause for delay in sale of assets of the company. We district town channel of Faridabad, not issuing an NOC for sale of them. Meeting data, read on. Now let us go back to the print again. Paragraph 13. In another meeting. Are you placing the plane? Am I not hearing you? You are placing the plane. Be bold. Page 150. So let's go to the contempt. Mr. Ayush. No, the trail one. Come on. Mr. Ayush Mukherjee reiterated. So this is the 158. Are you named in the scheme? You are named in the scheme. Have they annexed the scheme? Show me. One, 5, 9. Yes. You are, no, that's the defendant. Show me that you are named in the scheme. Baja has been named. Yes. So come to the plate. Interim. Parties were addressing on the issue long time. Where? Yes. Acha. That reconciliation can be, why can it not be done at the time of trial? Section 12A, the little I could understand on it, is for last 5.5, I was absolutely not in touch, and most of the amendments came after my elevation. So what the little I could understand is, relief doesn't matter. Tell me. Yes. So at the end of the day, ultimately it is an interactive session between the two sides. Relief doesn't matter. Whether you succeed, whether the plaintiff succeeds, ultimately doesn't matter. It only matters at the 12A stage is to protect the interest of the plaintiff if an imminent threat is there, according to the plaintiff, because the statements in the plaint has to be taken as sacrosanct, and it is correct at this stage. So relief does not matter unless you show glaring ecstasy that it is barred by law. The plaint itself is barred by law, which has no right to be borne on the board. Then that can be a prima facie case. Otherwise, it's all prima facie case. It is all absolutely a prima facie case. If the plaintiff pleads, then look here, I have a claim of 10 lakh. If this property, valuable property goes in the meantime, by whatever way, not declared to be known to the plaintiff, then I will be penniless even if a decree comes. In this background, more so, Order 38 will fly, 5 will, the principle, I'm not on the law itself, will have to be applicable a little bit to appreciate and ascertain the pleading on threats. Right? So if a threat comes, which is in a close proximity, of course, if the threat comes needed, if the plaint is of 2 years back, no urgency. But if the threat comes, let's say, within first few months or something like that, then why the deal will not be done? Plaintiff may not succeed at the time of trial. After trial, it may be dismissed. It may not succeed. But 12A has got nothing to do with it. That's my understanding. No, I'm not saying that. I'm saying, suppose you file a suit which is otherwise barred by Section 34 of the surface law. Very apparent. The suit has no right to be alive. In that case, court may consider it to be a prima facie case not to grant. I'm giving an example, sir. Suppose reading a plaint shows are clearly barred by law. Then the question of even accepting for 12A does not arise. This is not such a case. So the urgency, it's also a perception, depends from court to court, facts to facts. I'm coming. Within 5 minutes. You're doing very well. Continue. Mr. Banerjee, after he completes, I will hear you. No. Sir, the list is such, I will complete. I'm coming with I'm coming. If you have to cite any judgments, huh? So place it. I'm coming and I will take the judgments. Yes. Yes, sir. Yes, sir. That you will have to satisfy subsection 1. A suit which does not contemplate any urgent interim. Be louder. Take the microphone and be louder. What is this delay? Condo? Oh, okay. The application and also Rule 11 filed by the petitioner, any defendant such and such has been rightly dismissed. Chalo, next. What was the ground for Order 7, Rule 11? So kindly come to paragraph 3. This only party ordination. you have to show that this suit does not contemplate any urgent relief. That's all. Show me that. Show me that.
Your chips have read paragraph.
Yes,
Paragraph 10. We are of the opinion.
Yes.
We are of the opinion that when a plaint is filed under the Commercial Courts Act with a prayer for an urgent interim relief, the Commercial Court should examine the nature and the subject matter of the suit, the cause of action, very important, the cause of action and prayer for interim relief. The prayer for urgent interim relief should not be a guise or mask to wriggle out of and get over Section 12A of the Commercial Court Act. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff. Non-grant of interim relief at the ad interim stage, when the plaint is taken up for registration or admission and examination, will not justify dismissal of the commercial suit under Order 7 Rule.
1 second. Non-grant of interim relief at the interim stage, when the plaint is taken up for registration, admission or examination, will not justify dismissal of commercial suit under Order 7 Rule 11 of the court. At times, interim relief is granted after issuance of notice, nor can the suit be dismissed under Order 7 Rule 11 because the interim relief post arguments is denied on merits. As I said.
Yes.
Yes.
The three principles: prima facie case, irreparable harm, balance of it. The fact that the court issued notice and or granted interim stay may indicate that the court is inclined to entertain the plaint. Then, my lord, having stated so, it is difficult to agree with the proposition that the plaintiff has absolute choice and right to paralyze Section 12A of the Commercial Courts Act by making a prayer for urgent interim relief. Camouflage and guise to bypass the statutory mandate of pre-litigation mediation should be checked when deception and falsity is apparent or established.
When deception and falsity is apparent.
The proposition that the commercial courts do have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiff alone to decide whether to resort to the procedure under Section 12A of the Commercial Courts Act. An absolute and unfettered right approach is not justified if the pre-institution mediation under Section 12A is mandatory as held by the court in Patil Automation. Then, my lord, the words contemplate any urgent interim relief in Section 12A subsection 1 of the Act with reference to the suit should be read as a conferring power on the court to be satisfied. They suggest that the suit must contemplate, which means the plaint, documents and facts should show and indicate the need for an urgent interim relief. This is the precise and limited exercise that the commercial courts will undertake, the contours of which have been explained in the earlier paragraph. This will be sufficient to keep in check and ensure that the legislative object or intent behind the enactment of Section 12A of the Act is not defeated. So, my lord, the courts have held that it should not be a guise or a choice to the plaintiff to come before your lordships and seek leave under Section 12A for the asking. My lord, urgent relief has to be contemplated, and the circumstances should suggest that there is urgency. Now, here I want to show, my lord, that parties have been dealing since 2011. Last payment made in June 2024. Then, my lord, cause of action arose because, my lord, the pleading is that no further payment has been made.
No. Last payment made June 2024, it sets the limitation. Or the moment part payment made, it is an acceptance of the debt.
But also, my lord, the pleading is that the parties are agreed that upon delivery and acceptance, the payment would be made. So, my lord, if the payment has not been made after June 24, the plaintiff had a right, my lord, to seek any redressal.
Huh?
But after June 2024, when further payment was not forthcoming,
If the payment is not would not have been made in June 2024.
Yes, madam.
Could not the plaintiff initiate the suit?
Yes, that's what I'm saying, my lord. The cause of action had arisen in June 24.
Why?
Because the
cause of action has arisen the day you defaulted.
Yes, madam. The pleading. I'll show the
Payment of the bill raised by
the bill says that the payment will be made upon delivery.
Right. So delivery took place on 24th June.
Much prior. The pleading and the bills show that the delivery has been made much prior.
Right.
The last payment is made on June 24. Thereafter,
that pleading is made to show that it is a continuous cause of action,
Yes,
no
ma'am.
limitation.
Also, madam, my submission is that the cause of action had accrued when payment was not received in terms of the terms of delivery.
Sir, that is not to be looked into, in my view. 12A and the Supreme Court, the way it says, 12A, the Supreme Court has clarified. 12A, as I said, the reading of section 12A in my view is ultimately the suit may fail. Ultimately the interim order may be refused on hearing.
Yes.
But taking the statements in the plaint to be sacrosanct, whether the contemplation is there or not. That's the test.
Now, my lord, my submission to that is, if the plaintiff cannot delay its cause of action, but once the plaintiff has come to know that further payment has not been made in terms of the delivery, my lord, cause of action had arisen. My lord, the plaintiff delays it. Then, my lord, plaintiff enters into discussions with the defendant for arriving at a compromise.
Here the plaintiff contemplates urgency in view of those two emails, 157 and 158 or whatever.
Yes, both. You're
those two emails.
Lordship is right. 157, 158. My lord, in February, but it records
June.
In February and thereafter in March. February
So
of 25.
they contemplate that.
February 25, it has been discussed that yes, the parties will, the defendant will sell its property and arrive at a settlement with its creditors, including the plaintiff hearing. Party also discussed that the scheme of compromise has been filed in the NCLT.
Scheme of compromise doesn't matter, in my view, because scheme of compromise really admits your debt.
My
payability to you.
My submission to that is, my lord, the admission is to the extent of the settlement amount, which is 19 lakh odd.
No. Unless the scheme, so long the scheme is not sanctioned.
Yes.
And you are not participating, does the scheme is binding on you?
Not at all. Not at all. No, it's a scheme which has been proposed. But yesterday,
even if it is sanctioned, would it be binding on you?
But if the scheme is sanctioned, then it would be binding on all creditors.
Then it will be binding on creditor. Correct. The creditor has to participate.
But that sanctioning, that first meeting is called.
Yeah, correct.
After
so
the meeting, it is
creditor's
sanctioned.
meeting will have to be there before the IRP.
No, my lord, it will be by a special officer appointed by the NCLT.
Oh, whatever.
Yes.
Whatever.
Yes.
Whatever.
In the meeting, the creditors have a right to vote. If the meeting secures, my lord, a majority vote, then it is placed before the NCLT once again for sanctioning.
If one creditor says that I will not participate.
But then even despite one creditor not participating or voting against it, if the majority is achieved, I showed, my lord, there are 40 or 45 creditors. If the majority of the creditors accept the scheme, then it is placed before the NCLT once again. If the NCLT finally sanctions the scheme, then it becomes binding on the company as well as all stakeholders. But
that is neither here nor there, because you have not come with a plea that in view of the sanction scheme, stay the suit.
No, madam.
That's not your plea. Your plea is that there is no imminent urgency
Yes.
So 12A ought not to have been granted.
Yes, yes. Because my lord, the contention is that the parties were already in discussions and all the facts were within the knowledge of all the parties. My lord, my submission is that the urgency has been created. The urgency has been created. Had the plaintiff, my lord, come before your lordships immediately upon coming to know that I'm trying to sell my property, then, my lord, I would not have anything to
No,
say.
the way you, whatever you are saying, largely will depend on trial. Largely will depend on trial, that how long the parties were negotiating, how long the fact was known to the plaintiff. But when a plaint comes, the court shall look at the statements on plaint to be sacrosanct and correct.
Yes.
And if the contemplation of urgency is there, 12 were permitted.
But the plaint itself says that from
For
February.
injunction, for
Yes.
moving an injunction.
Yes.
Not as of right to get
I
an injunction.
bow down, my lord. I bow down.
For moving for injunction.
But my submission is that from February, as per the plaint case itself, from February parties were in discussions. And
The email says that one authority before whom your permission is pending. Now, if tomorrow the permission is granted, who will prevent you from selling?
But the parties had already, well, there is no opposition in that email itself. There is no opposition by the plaintiff that no, don't sell the property, or well, pay me first and then sell the property. So, well, the contemplation of the sale of property had been there from at least from February 24. And well, the plaintiff had agreed to that sale. There is no opposition at all. February also, March also.
The moment you say there is no opposition at all, right?
Yes.
The moment it's a case for trial. Because the court has to look the plaint and only plaint. Not what it will happen at the time of trial.
Then, my lord,
yes, now I will hear you, senior.
Grateful, man.
You have done very well.
Grateful, man.
You have done very well. And henceforth, you will do the matter. Don't look at your senior.
We will anyways have to do it post 2 o'clock today, if your lordship permits that.
Yeah, come on. You take up.
No, this judgment has been placed before your lordship. But I'll just summarize what my points are. One is 12A is a mandatory provision. You can't use the rules of urgency to bypass a statutory mechanism, which is otherwise mandatory in nature. Now, in that context, this judgment has been placed. I'll not be troubling you with your lordship with the same judgment again, except that the plaint will have to be seen if the urgency is a meaningful cause of action, or is it something that we do it as a matter of course, let's take leave and go ahead and do it. That kindly comes back to the plaint once more. I'll just trouble your lordship one more time. Please have a look at page 18 once. I'm sorry, my lord, page 17. Paragraph 8, last sentence. Last of such payment was made in the month of June 2024 against earlier dues not forming part of the outstanding invoices which are subject matter of the instant suit. During February 9, paragraph 9, during February 2024 to June 2024, the plaintiff supplied goods total at value of so and so on both accounts for which no payments were made by the defendant. Total sum and so remains due and outstanding till date. The suit is for recovery of money. In the plaint, there are no other reliefs except for a sum of money. So his cause of action, I'll show from how he's pleaded and taken leave under clause 12. His cause of action arises for recovery of money in June 2024. My first point is, there can't be a postponement of cause of action by relying on correspondence exchange between the parties. Point one. So, well, keeping in mind the Supreme Court decision, whether this urgency is an ostensible urgency or whether if it pertains to the cause of action, he ought to have taken recourse to the mandatory provision under 12A. I'm not on 711, I'm simply sit on section 12A here. So his suit for recovery of money, cause of action arises in June 2024. Then your lordship will kindly read on, my lord. The parties were maintaining running continuous account upon adjustment of all payments made by the defendant as per the ledger. In respect of said account of defendant, there is total outstanding sum of so and so which commensurate with account invoices from February to June. So again, this fact is highlighted. He identifies all the outstanding invoices as on June 2024. So there is absolutely no whisper in the plaint as to why his cause of action, which had accrued in June 2024, he's going to bypass mediation and come in April 2025. I'll come to his so-called, in my understanding, ostensible urgency. Please have a look at paragraph 12. In the meeting held on 4th February 2025 at the registered office of so-and-so, the representative of the defendant expressed that the defendant is in dire straits and in requirement of funds, and for such funds were to sell their plane. Please mark this, this is February 2024. Were trying to sell their plant, 2025, were trying to sell their plant situated in so-and-so. Further, it was informed, then the scheme, most importantly, the discussion of the meeting was recorded, and your lordship will find that in that, at page 157, which was given, a draft copy of the scheme was given. So February 2024, he gets to know, 2025, he gets to know that A, I'm proposing a scheme. B, my financial condition is in doldrums. C, I am trying to sell off this land. The statutory mandate under 12A, the mediation period is specified. This suit is filed in April, that is after 2 months from this date. This particular paragraph, if your lordship now takes up one more paragraph, at page 22, paragraph 21, on what he has pleaded as his cause of action which has arisen within and cause of action which has arisen outside, he identifies these paragraphs to be paragraphs for cause of action. So I don't have to argue anymore that this is his cause of action or not. So his cause of action accrues in June 2024 by his own case in paragraph 21. Using that, he takes clause 12 leave. He specifically refers to paragraph 12 when in February 2025 he knows that I am to sell off this property. So my reiteration of that in March makes no difference. Your lordship can put this query to me that from a reading of the plaint, I am going by what is urgency. But if I have to draw inspiration from a Supreme Court judgment, your lordship is now well entitled to see as to why a mandatory provision has been given a go by. How can you today, for a cause of action that has accrued, and your lordship will come back to a judgment once, not what is contemplated in the suit, your lordship will find that that contemplation has nothing to do with the injunction application. That he has filed an injunction application is not the test. His suit contemplating urgent relief is, kindly have a look at that particular paragraph. It's the six. A suit wherein word contemplate connotes to deliberate and consider. But if your lordship turns over, please have a look at paragraph 35, which is part of paragraph 9.
35 from?
Same paragraph 9.
Huh?
It's a quoted portion. Paragraph 9 of the judgment. The Chandra Kishore Chaurasia is quoted. Paragraph 35 of that. 34 also, my lord. The use of the words contemplate any urgent interim relief as used in section 12(1) of the Commercial Codes Act 2015 are used to qualify the category of a suit. This is determined solely on the frame of the plaint and the relief sought. The plaintiff is the sole determinant of the pleadings in the suit and the relief sought. This court is of the view that the question whether a suit involves any urgent interim relief is to be determined solely on the basis of the pleadings and the relief sought by the plaintiff. if a plaintiff seeks any urgent interim relief, the suit cannot be dismissed on the ground that the plaintiff has not exhausted the pre-institution remedy of mediation under 12A. We are of the opinion that when a plaint is filed under the Commercial Courts Act with a prayer for an urgent interim relief, please mark this, the plaint, here there are no reliefs in the plaint apropos any property, nothing. In fact, there are no interim reliefs in the plaint itself.
Not required.
Not required. There is no with regard to the property, not required.
Not required.
39(1)(b), he can come and see.
Absolutely.
But the determining factor is,
or order 38 rule 5.
Or 38, even if he wants to take a property, 39(1)(b). I am not on that. I am saying that the determinate factor is the pleadings and the relief that he sought for in the plaint. Please come
and the perception of the court.
And the perception of the
which varies from court to court.
That's right. Which is also held here.
So I've read that.
Yes. If I may just come back to that, Manoj. The commercial court should examine the nature and the subject matter of the suit, the cause of action, and the prayer for interim relief. The prayer for urgent interim relief should not be a disguise or mask to wriggle out of and get over Section 12A of the Commercial Courts Act. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff. Non-grant of interim relief, then it goes to 711, what is to be there tested. So now if your lordship takes the plaint, he comes and seeks, pleads urgency in April to wriggle out of 12A on the ground of something that is his cause of action by his own case has arisen in June 2024. He uses correspondence to postpone that cause of action, and his next date that he highlights is of February 2024. Even as on February 2024,
no,
I'm sorry, 25.
The plaintiff does not postpone his cause of action. Cause of action, what has happened, has happened. Limitation will run from that. It's plaintiff by showing those two emails pleaded. And look here, they are now in the process of selling off its asset. In the process.
So his relief.
That process, how far true, how far correct, how far not to be accepted.
To get into that.
That's I cannot.
Lordship need not, which is why the plaint is so important.
Absolutely.
Please come back to paragraph 10, that one line once more. The commercial court should examine the nature and the subject matter of the suit and the cause of action.
Correct.
So his own pleaded case, where he takes clause 12 leave, his cause of action by his own plaint case has arisen in June 2024. There's a whole lot of facts.
Had it been a case that the plaint says cause of action is already, whatever reason, is already barred by limitation on the prayer of
limitation.
On the plain look on the plaint. On the plain look on the plaint, if it appears to the court that the way cause of action is pleaded, court is in the mind, it might be barred by limitation. Then why should I allow?
Limitation is one, that's 711D. Prima facie, ex facie, that's one bit of it. I am only on whether this is being used as a ruse to get out of 12A.
The ploy.
Unhesitatingly, that's the right word, not the ploy. Because whether I am getting out of that mandate. So what your lordships are going to consider is the frame of the suit, the subject matter. What is the subject matter here? Money. That's the subject matter of the suit. What's his relief? Suit for recovery of money. What is his cause of action? Pleaded case, cause of action is June 2024. His next date is February 2025. That too. So even if I allow him to stop the clock at February 2025, now it is for your lordships to determine whether when a cause of action has arisen June 2024 in respect of a subject matter of a suit for recovery of money, whether pre-institution mediation will be given a go-by or not. His case that I have come to know in March that I'm selling the property is in aid of the relief, which can be one part of a cause of action which by his own
Very
case
well.
is
Take a situation that despite this mail being there of March, that you are in the process of selling. You are in the process of selling. Leave is not granted.
May I just place it slightly?
He has gone for mediation. In the meantime, you sell out. Then what will be his remedy?
But in any event, when he files the suit, by then we had sold it out. That was before the court. He gets an injunction, does not comply with 39(3)(ab). I come and take the point and I tell the court that property was sold out. So
No, that's right. But
another aspect of it. Look, please considers it from two different aspects. This is again, as your lordship very rightly pointed, like an exchange. So I'm also giving a situation where these two emails are not there. Or a situation where these two emails are not there. Would your lordship have granted him leave in 2020?
May not.
Now, next is where February he comes and says, I have come to learn that the party is selling. And he institutes a suit exactly 2 months later. Would your lordships have granted that leave to him? Because his urgent interim relief is not the sole determinate test. The test from a holistic view of the cast of his suit is the subject matter. This is not an intellectual property dispute or a partnership where there's a dissolution going to happen, asset is going to be sold, which is why your lordships have now restricted the consideration. One of the aspects is the subject matter. It's a suit for recovery of money.
Now, if you go by that argument, that suit for recovery of money, injunction is not required to be passed.
It is. If my money is outstanding from June 2024, you come in, let's say, sometime in 2024.
No, I'm not
the
on that.
financial doldrums.
I'm taking those points, those earlier views, that where injunction is not to be granted, when it is
88 Calcutta.
88, then 2008 or 6, something Supreme Court. Ramantek, yes. So those will not strictly apply for under the Commercial Court Act.
Not for 12.
Because
I'm not going to argue.
Yes, because Commercial Court Act takes care of this type of suit.
I am so grateful. These last 3 words that I just fallen from your lordship is the most important determinate factor. This type of suit. So his type of suit is a suit for money.
Yes. Where injunction is permitted.
Yes.
Under the Commercial Court Act.
But his question is whether he gets out of 12A or not.
Whether he needs an urgent injunction or not. Whether he pleads the case for urgent injunction or not. Does not matter whether he will ultimately get it or not, or whether lose it or not. Irrelevant.
That is it.
His suit may not succeed ultimately.
He must contemplate an urgent interim relief. Now that urgency, whether it's borne out from his cause of action or not. Now it is for your lordship now, my lord, to do this arduous task of whether he has exemplified any urgency in respect of a cause of action in a suit for recovery of money, which in his own case has arisen in June 2024. Even then, in February 2025. And then he takes it and files in April 2025. 2 months later. Whether the claim justifies, it's 120. Lord,
so you have completed, I believe.
There would have been one more judgment.
Give it.
On this. Lord, we'll cite that. Your lordship will allow Mr. Kejriwal to address your lordship.
No, you can cite it now. And then. Thank you, Kalke. Yes, give it.
It's on the same principle which is now culminated in the Supreme Court decision.
So you have completed?
Yes, with regard to this revocation, yes, for clause 12. I mean,
section 12. Thank you.
If Mr. Ray argues, then
if he cites any judgment, then your junior will deal with it. But today I will complete today itself.
This one.
Huh?
This application.
12A.
On the other application, my lord, may I
other applications, my lord?
Yes, I have to
Yes,
here
once your lordship.
complete this, then it depends.
Because it's 8 and 9, my lord, so I will only beseech your lordship. If it is in my favor, then lordship will kindly give me some precedence for those two matters also, my lord.
No question of precedence. If I have time, I will take up.
But today, your lordship will not take on post 2. I'll not be able to be here. That's his injunction and attachment before judgment application.
Mr.
Please do it
Banerjee,
on Monday, my lord.
I see that.
To be honest, there's a bench that's constituted from 2 only to be hearing me on a point of.
No, but the thing is, I tell you, I
No, I
don't mind,
understand,
but
but
the thing is,
I
then
would have
it will not appear. It will not appear soon. I have to justice all other matters.
People hear him on the point of 12A. If I can come back, I'll deal with it.
Of course, I will 12-way, I will complete
Item
today.
8 and 9 instead of
And
today
I will
on
deliver my decision in court if possible,
Great,
by
my lord.
dictating.
8 and 9 instead of today, just Monday.
Let's see,
that.
let's see. I don't.
Kindly considers that.
Yes, if he consents.
No, it could have been taken up together.
Let's see. So I'm coming back. Start at 2.
Yes,
You have to judgment. You have any judgments?
I'll show one judgment.
One judgment?
Other than Yamini Manohar.
So give it
Yes,
to
yes,
him. Give it to him so that he can get. In the meantime,
all
he
right.
can go through it.
Can't lose everywhere.
All right. All right. 3:30 আছো
Lordship's kind leaves.
This is not the time to mention.
Lordship, just for short service of a master summon, because your Lordship, my period for filing my written
This is,
statement
you
is
should have
coming.
come in the morning.
Lordship,
This
it
is
has
not
been
the time.
affirmed just a few minutes back, your Lordship. It has, the application has been affirmed. Short service of the application for condonation of delay of filing the written statement, your Lordship. The period is coming to an end on Tuesday, your
What is the day? Between 30 to 120?
86 days, your Lordship.
File it. It's no requirement of short service. 120 days time is still
Lordship,
there.
30 plus 86, that is 116 days total. My 120th
Come
day
in
is
the
on
morning.
Tuesday.
Should have come in the morning.
Lordship, it was not affirmed. It has now been affirmed, your Lordship. All I'm seeking is for short service of the master summon upon the other side, so that the application can be listed on Monday and we can file the written statement. Written statement is also affirmed. The application has also been affirmed, your Lordship. Written statement has also been affirmed.
Leave granted for short service of master summons.
Obliged.
অ্যাফার্ম দেখি কি হয়েছে আগে অ্যাফার্ম হয়েছে কিনা স্ট্যাম্প পাঞ্চ হয়েছে কিনা স্ট্যাম্প পাঞ্চ স্ট্যাম্পড এন্ড পাঞ্চড
It has been affirmed, stamp punched and affirmed.
হয়নি স্ট্যাম্প পাঞ্চড একটু কি স্ট্যাম্প পাঞ্চ করে তাকে ডাকো তো কেন এরা বলছে যে না হলে হবে না স্ট্যাম্প রিপোর্টারকে একটু ডাকো তো কালকে ডাকতে বললাম বিকেলে ডাকলে না চেম্বারে আরে চেম্বারে এটা তো ডাকতে হবে এইভাবে তো করা যাবে না ভেরি ওয়েল ইউ ওয়েট স্ট্যাম্প পাঞ্চড স্ট্যাম্পড এন্ড পাঞ্চড
Yes, your Lordship.
দিয়ে দাও আর স্ট্যাম্প রিপোর্টার এলে আমার সঙ্গে কথা বলবে লিখে দাও লিখে দিয়ে ছেড়ে দাও মাস্টার সামান্স হ্যাঁ হ্যাঁ ওয়েট 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 Yesterday I have delivered my judgment. Look at it. If it helps you. Yesterday the chamber application, only one chamber application in the list.
So there is an interim order of injunction as to invocation of a bank guarantee, which is being extended from time to time. And lastly, my lord, till 6 November 2025, Yesterday it was in the list, but my lord, it could not be called. My lord, we tried to mention at the time of rising. My lord, it's our fault. We should have come in the morning. My lord, I can't.
It is expired yesterday.
Yes, my lord, it has to be
Lordship, in this, we have deposited the whole amount and it has been converted to a FDR and kept with the defendant number 1, that is an Indian bank. So now I don't suppose there should be any injunction is required because bank guarantee is being deposited in a bank itself. FDR is created. Now there is no renewal.
That will also serve the purpose. Then it need not be extended. My lord, it was an order of injunction passed. Despite the order, my lord, it was invoked by the authority who my learned senior friend appears for. Thereafter, my lord, we find.
Despite injunction, you have.
Yes,
no, Lordship, just I tell you, when the order was served to us, it was later upon served to us, and prior to that, the bank guarantee was invoked in Kolkata. And later upon, it was a Saturday.
Reimposing.
Yes, my lord. Kindly.
Lordship, and a date may be given.
21st August is the last order.
Last extension on
21st August 2025. My lord. Extended till 6 November 2025.
And Lordship, there is a issue of a arbitration clause. Section 8 application we have already moved.
Also pending.
That is also pending before the Lordship. GA3.
The interim order last extended on August 21, 2025 was valid till November 6, 2025. Bracket A, yesterday. Full stop. The matter was running in the list on yesterday, but since the business of the court did not permit, the matter could not be reached. Paragraph. Today the matter has been published upon mentioning the matter has been published in the supplementary list. Full stop. Mr.
Mukhopadhyay, Shaunak Mukhopadhyay.
Shaunak Mukhopadhyay, Learned Counsel, appears for the plaintiff. Mr.
Tanuj Gupta. Tanuj Gupta, TANUG.
Mrinmoy Chatterjee for defendant number 1.
Mrinmoy.
Mrinmoy.
Mrinmoy Chatterjee, Learned Advocate, appears for defendant number 1.
Tanuj Gupta.
Paragraph. Mr.
Tanuj Gupta.
Tanuj Gupta, Learned Advocate, appears virtually for
defendant number 2.
Defendant number 2. Full stop. Paragraph. Though it is submitted by Mr. Tanuj Gupta, paragraph, appearance guru shop paragraph, that the entire proceeds under the bank guarantee after invocation has been kept in a separate account. But at this stage, since the interim order has expired yesterday, this question can be gone into later, and the interim order last extended on August 21, 2025, which has expired on November 6, 2025, stands reimposed till January 30, 2026, or until further order, whichever is earlier.
Yes.
Full stop. That's all.
Well, the matter will continue.
Oh, so sorry. So sorry.
The matter will continue in the list, my lord, in its same position, my lord. The matter was there.
It is in the list.
Today it isn't because my lord is taking up different.
All right.
Yes, obliged.
30th January.
10 তারিখ অফ 10-11 আছে, ঠিক আছে। আর তোমায় তো বলে দিলাম যে আজকে যেগুলো হবে না সেগুলো লিস্টে দিয়ে দেবে, তাতে এরকম সিচুয়েশন হলে ইন্ট্রিম অর্ডারটা পরের দিন এক্সটেন্ড হয়ে যাবে।
Next date is 30th of January.
Yes. Next.
Item number 2.
Item number 2. This is also skipper stay, skipper limited.
These are interlocutory applications to the same suit, my lord. My lord, the interim order was there only in the first item. The others, my lord, were ready for hearing adjourned motions, my lord. They can be listed on another day.
And the first one is new motion.
No, my lord. All of them are adjourned motions. All of them are post affidavit. All three are post affidavit.
তাহলে এই তিনটেতেই একটা অর্ডার করো, এইটা করো, ঠিক আছে? তিনটে আইটেম লিখবে, লিখে একটা অর্ডার করবে, করে লেখো all the connected applications shall appear under the heading adjourned motion. তো কবে বলেছে এই প্রদ্যুৎ? হ্যাঁ, as already fixed on November 10, 2025. As already fixed on November 10, 2025. Huh? Huh? For analogous hearing. Your section 8 is there.
It is logged out, my lord.
Section 8 is
Yes, my
there.
lord. Yes, my lord.
So
It's
section
there.
8 will be hard
Yes,
fast.
my lord. Yes.
Next.
Item number 4.
The pending, ওখানে লেখো, the pending section 8 application shall be hard fast. ঠিক আছে?
My lord, I mentioned this matter, my lord, in the morning.
When expiring?
Today, my lord. My lord, this is the order of the coordinate bench, my lord.
Since the interim order last extended on?
My lord, this is the first extension happening.
Oh, passed on? September 25, 2025 is expiring today. আজকে হচ্ছে 7 নভেম্বর।
7 November.
এই এটা কেন লিস্টে আসেনি 7 নভেম্বর? ও এখানে লিস্টে ছিলই না। অলরাইট, কি বললাম?
Compliance.
Comma. The matter has been included in the supplementary list for a limited purpose for extending the interim order.
I put them on notice, my lord, after mentioning, my lord.
Mr. Rajarshi Dotto, Learned Counsel, appears for the petitioner. Mr. Arindam Mukherjee Banerjee, Learned Senior Advocate, appears for
The defendant.
the defendant. Paragraph. Paragraph. The interim order stands extended till January 30, 2026 or until further order, whichever is earlier.
My lord, 2 affidavits of service. One, my lord, compliance of the, my lord, direction passed in the previous order. I was required to serve plaint and
2
petition.
affidavits of service
And
filed
one
in
is
court
today's
today
notice.
by the petitioner is taken on record.
Grateful, my lord.
Sure.
Chilo na, kobe de korna. In the meantime.
The meantime, Lord, if we could file our affidavit, Lord, to the GA. Our affidavit to GA what?
Lordship can issue that direction also so that we can complete the affidavit and come back.
Paragraph. On the joint prayer of the parties, the respondents shall file affidavit in opposition on or before.
And give me 2 weeks. 2 weeks will be.
On or before November 27, 2025. Paragraph. Affidavit in reply, if any thereto, shall be filed by December 18, 2025. The matter shall appear under the heading motion adjourned.
Motion adjourned.
Motion adjourned on in the monthly list of January 2025.
Grateful, my lord.
2026. 2026.
We also want to
6, 7, 8.
Aging.
No. These numbers are boggling nowadays. Time is going so fast.
2026. Chalo, next.
Very grateful, my lord.
হ্যাঁ, একটা কথা বলুন তো আমাকে, এখানে উকিল বাবুরা বলছেন যে আমরা যদি লিভ যতক্ষণ না দিই, যে শর্ট সার্ভিস অফ নোটিস মাস্টার সাম
Well, it will also consider, my lord, if I may permit, the question of a master summons in a commercial suit, my lord will kindly consider that, my lord.
No.
Because the role of a master is not there in a commercial suit, my lord.
Then
But I think there is a practice direction which has been passed, my lord, with regard to all these chamber directions. I think they are also going to be under notice of motion, as far as I remember, my lord. So, my lord will kindly, because
that we'll have to see. Let's see. Let's see. After all, this is an authority to register the application. That's all. So let them do that, because I tell you why. As
no,
I
what
was
you
saying-
felt from me is absolutely correct.
No, that's all right. Chalo.
Or else again, my lord,
He may not file. Bearing the signature, I send to হাত মুছে ফেলে দিল। কাল থেকে কোনো মাস্টার সামান্স নেবে না যতক্ষণ না স্ট্যাম্পড এন্ড পাঞ্চড হচ্ছে। If somebody has urgency, he will come up for the leave for short service.
Absolutely.
Otherwise, 4 দিনের মাথায় returnable হবে। চলো, next. Yes. শুরু করো।
my lord will kindly take the Commercial Courts Act once, my lord, and then I'll take a lordship to the plaint. And not too many paragraphs, my lord.
Yes.
My lord, we are only concerned with only one section at the moment, my lord. It is 12A, my lord. My lord, may I just read it for your lordships, my lord? Also my satisfaction, my lord. My lord, 12A is not a complete bar. First. So 12A qualifies the bar.
Take the microphone.
Oh, sorry, my lord. 12A, hello, my lord. 12A qualifies the bar. Now, my lord, kindly may I just read the first sentence, first line. A suit which does not contemplate any urgent, my lord, the next word is very important. Interim relief. It's not relief. So the only thing is, where the suit is not contemplating any urgent interim relief, section 12A comes in. So the question is, on the date of when I am filing the suit, but the cause of action is not the concern under the section. I'll come to the judgment of Yamini Manohar, my lord. I'll come to that. But other than that, if we take the section, my lord,
Yamini Manohar also does not say cause of action is a vital factor.
it doesn't. It says all of them has to be looked into.
Yeah, it says you just read it, the cause of action.
My lord, that is it. My lord, I have got a major history with regard to Yamini Manohar, my lord. As a matter of fact, the bench which passed this judgment, when I went up for an enforcement of that, they said, no, you go back. Don't have to look into it. It's a generalized judgment. So, my lord, I'll come to that later. Now, so, my lord, the main thing is it should contemplate an urgent interim relief.
And you may get, you may not get.
Again, Yamini Manohar explains that you may get, you may not get, doesn't matter. But
Result
what I'll
doesn't
have to
matter.
show is an urgent interim relief.
Correct.
What
Result
my
doesn't
learned,
matter.
yes, what my learned friend suddenly said, we'll only look at the plaint. No. You might look at the plaint, but you will also consider whether the suit would contemplate any urgent interim relief. Well, what is the meaning of contemplation?
The plaint must carry that averment.
Averment, and I must contemplate in my mind that it is an interim relief which I need.
It depends on the perception.
Absolutely. So it's a perception. Now, my lord, next point is, my lord, what is the case I have made out? Kindly see, my lord, though my learned friends have been trying to make out a case that the court should examine the cause of action, when payment has been made, when payment, and my lord, it is of no concern. As long as I contemplate, there is a scope of urgent interim relief.
And to my mind, so long it attracts the reasonableness of
my
the mind of the court.
And obviously.
And the court should take a reason, whether with reasons, with its mind, it contemplates some urgency for interim relief or not. At least prayer for interim relief.
Prayer for interim relief. Whether I will
Question-
get it or not get it doesn't matter. Now, in my plaint, my
Even
lord,
your suit may not succeed at the trial.
may not. Now, my lord, in my plaint, my lord, why did I file the suit? My lord, negotiation, I have also mentioned that. I said that this property was going to be only sold for the purpose of paying me out. Then what do? They get a draft scheme. It's not a scheme, my lord, draft scheme which they gave us. And what did the draft scheme say? I'll just take it only for 1 minute. Well, I'll just take your lordship for the bit.
You come to your plaint.
I'm on the plaint. My lord, kindly sees, my lord, paragraph. Kindly sees paragraph 12.
Yes. Yes.
My lord, 11, I have said that the defendant failed and neglected to clear the dues. Then, my lord, they sat in a meeting where they said that they are in dire straits and requirements of funds. And for such funds, we're trying to sell their plant situated at Sadoipur industrial area, Faridabad. So where I asked for the money, they say they're in dire straits. They want to sell the plant. So obviously, I contemplate that I'll get my money. Then they come and say that we are going for a scheme of compromise for settlement of the dues of the creditors. And we had specifically said, no, that is not possible. We are not agreeable. Why we are not agreeable? Well, kindly see the scheme once. And kindly takes, my lord, volume 2. I'm taking their application only, my lord.
Page 171.
Well, kindly takes 171, volume 2, GA3. Serial number 4 at page 171, my lord. My lord, what do they propose? I say I do not agree to this. They are admitting the amount outstanding is 99 lakhs. And they are proposing 19 lakhs. Why will I take it? Admitted amount 99 lakhs. That is why I come to court. Why do I come to court now? Kindly consider. I say there is this plant which is saying that you'll sell and you'll give me the money. Now I find that they're going to sell it and they're going to dispose of the, take away the asset, and that's it.
Of which you will be he will be paying 19 lakhs.
I don't know whether he'll be paying also not.
No.
That's what he's proposing. He admits 99 and he proposes. It is for me to accept or not accept. So, my lord, kindly appreciates the larger picture. I come to court. I get an injunction. So, my lord, the court finds that yes, I was entitled to an urgent interim injunction, which, my lord, was to a certain extent defeated by them coming and saying that no, 2 weeks back we have sold it off.
2 weeks?
2 weeks prior to the suit, we have sold off the property.
They have?
Yes.
So now where is the question of injunction? Where is?
My lord, I'll come to that. On these facts and circumstances, my lord, my learned friends come and say there is no urgency. Kindly considers this.
Show me the order where it is recorded that 2 weeks back before the suit.
Yes, yes. Hey,
order.
Yes. My lord, your lordship will not only see the order, my lord, IAGA number, 3 to next 3, my lord, I have filed for further security on this ground itself.
order যেটা বেশ বললো সেল করে দিই
পেজ
দিস ইজ এটা
এটা দিয়ে আছে তো
না এটাতে
কোনটা দিয়ে
193 দিস ইজ জিও
মানে GA1 সরি
এটা
ওই তো GA1 এ আছে
GA3 পেজ 193 তেও আছে GA3
আমি কোনটা দেখাচ্ছি এটা হচ্ছে ওদের 12 এরটা 12 এতে আছে
12 এতে
GA1 opposition, if your lordship takes, you will find that order. I'm sure the order file of page. Is the order dated 6th May 2025. 89 also. 389. It is GA1 or GA?
This is GA1. This is
GA1.
GA3.
আচ্ছা তো
না 16 এপ্রিলের পরে
পরেরটা 6th May এই তো রেকর্ড আছে 6th May 6th May 2025 5 8 or 9? 6th May 2025 হবে। It is also. Well, this is the order, your lordship will kindly see. This 6th May 2025, my lord. The last meeting held on 24th of March, and they come and say in court that, paragraph 5, the property in which this court has granted, the defendant has already executed a registered deed.
Prior to injunction.
That is what they're saying. After that, when the interim order has been continued, because some discrepancy was found in the registered deed itself, by the court itself. So the court extends the interim order. It's still continuing as a matter. I will be praying for an extension of that. If your lordship cannot take up 8 and 9 today, my lord, I'll be praying for that extension. Now, my lord, on the face of the 12A application, my lord, kindly now consider the situation.
Consideration will be second. Consideration will be second.
This is GACOM 1 is an injunction.
Yes.
Where already injunction passed, and then May 6,
they come and
stated
say
that sold.
Sold. So, my lord, therefore, I take out another application now.
That is G3.
For 2 was sold on
26th of March.
When you filed the claim?
6th of April.
They did not say at the time of moving the injunction. It was
they were expert. They came and told. But 24th, they hold discussion with me. 2 days, my lord. 24th March, whole discussion in 2 days' time.
All
so, my lord, my contemplation of an urgent interim relief, on the face of the facts, well, it is there. I don't know why my learned friend has been harping on this, that there is no contemplation, because cause of action has got nothing to do with this. It's only on the interim relief.
All right.
Then now, my lord, may I just take your lordship to the judgment? I don't want to waste the time of the court, because my lord, in a 12-way appreciation, your lordship is not, with humility, is not required to look into the merits of the case.
Certainly not.
I will just place 2 paragraphs of Yamini Manohar and the other judgment. Yamini Manohar to the husband. My lord has got Yamini Manohar. Mr. Banerjee has showed your lordship, my lord. My lord first kindly takes paragraph 9. It's not as if, my lord, the Delhi judgment has been stamped by the Honorable Supreme Court, my lord. My lord, Mr. Banerjee was placing, my lord, paragraph 33.
34, 35.
33, 34, 35. My lord, for the purpose of, my lord, because your lordship will kindly see, there is one access to comment 33 ought to have been claimed in a suit for determining the question whether plaintiff desires any urgent relief should be decided solely by the plaintiff when instituting a suit. The court may or may not accede to such a request for an urgent interim relief. But that is not relevant to determine whether the plaintiff was required to exhaust the remedy of pre-institution. Question whether suit involves any urgent
where?
Well, para 33 in that quotation, my lord.
You just read the last sentence in para 32. The court has no discretion to exempt the plaintiff from the applicability of 12A1.
Yes.
It is not permissible for the court to pass an order contrary to law. Therefore, an application seeking exemption from
engaging in
pre-institution mediation in a suit that does
not involve law. But that's why I said, my lord, it is qualified.
That's right.
And then your lordship will kindly see what is the finding of the Supreme Court, paragraph 10. We are of the opinion that when a plaint is filed under the Commercial Courts Act with a prayer for an urgent interim relief, the Commercial Court should examine the nature and subject matter of the suit, the cause of action, the prayer for interim relief. Mr. Banerjee was saying,
in my view, the expression cause of action used, in my view, principally to look at with a prima facie eye whether it is barred by limitation or barred by law.
Order 7, Rule 11?
Barred by limitation or barred by law, ex facie. If it is ex facie that, then the court shall not touch the plaint. That's why perhaps.
My lord, absolutely. I think what is falling from, because, my lord, just before this, there was partial automation also, my lord. where the Supreme Court held there's a suo motu right of Order 711 of a court.
It's a section.
And also Section 3 is also
It's
there.
a section.
Yes, the section is there. So therefore, my dear Lordship, at that point of time, it contemplate first that and then cause of action coupled with the interim relief. And that is why this has been given.
Even your cause of action may not succeed on merit after trial.
Yes, that is their next sentence.
The prayer for
non-grant of interim relief, just between precedent A and B.
The facts. Non-grant, yes.
Where the plaintiff is taken on registration evidence examination will not justify dismissal of the commercial suit under Order 7. At times, interim relief is granted after issuance of notice. The only thing which has been stated is in paragraph 11. The second sentence, camouflage and guise to bypass the statutory mandate of pre-litigation mediation should be checked when deception and falsity is apparent or established. But have I been false in anywhere in my pleadings? Because fraud, falsity, they overcome everything. The proposition the commercial court do have a role, albeit as not an absolute right, it's fair enough.
So you want to cite any judgment?
And only one judgment.
Show me.
And Madam 12 last in this one, they suggest that the suit must contemplate, which means the meaning of contemplation. Plain documents, facts should show and indicate the need for an urgent interim relief. Para 12, my lord, second sentence. They suggest the suit must contemplate, which means the plain documents, facts should show and indicate the need for an urgent interim relief. This is a precise and limited exercise that the commercial court will undertake. So very narrow, very limited. Now, my lord, this was a generalized, my lord, judgment, my lord, for the purpose of discussing section 12A. My lord, our division bench, my lord, report in this judgment, my lord, the unreported judgment, I've also already handed over to my learned friend, my lord. My lord, here, if your lordship straight away comes to but after discussing Patil and everything, my lord, kindly sees, my lord, internal page 9. My lord, the paragraph just after setting out, my lord. Say the plain discloses a simple money suit. Sorry, my lord. Phone started. But say the plain discloses a simple money suit. Now the question of money suit, which we were discussing, my lord. But it is likely that on notice of it, the defendant might start disposing of some of his assets to defeat the decree that might be passed against him. So the plaintiff may contemplate the urgent relief of an attachment judge need not plead it in the plaint. As the cause of action is not, it is in the time of institution of the suit. Please note the wording of 12A1. Legislature does not mention plaint. It uses the word suit. It employs the word contemplation. Hence, it avoids such words as averments or statements in the plaint. In other words, the legislature does not say that from a statement or averment in the plaint, urgent reliefs obtainable by the plaintiff should be apparent.
You suffered a defeat. Then?
That's what I said, but I can't lose at every instance.
Next.
And I would interpret the section such that if at the time of presentation before the judge from the averment of the plaintiff, an affidavit to be filed by the plaintiff, it would appear that the contemplating the plaintiff a situation for urgent relief might arise in the period when mediation has to be undergone. The court may allow the plaintiff to insist the suit without mediation. And my lord, my affidavit was my application. On the basis of the declaration that urgent relief is contemplated, the plaintiff should be allowed to present the plaint. And my lord, the erroneous, kindly see the last sentence on that. Court should not ordinarily interfere with such assertion unless it is shown to be palpably erroneous or malafide. Once the plaintiff is allowed to file a suit without pre-litigation mediation, discretion of the court should not be allowed to be interfered with at a later stage. Otherwise, the proceedings are likely to become very dilatory. Even after filing of the suit, the parties can be referred to mediation, the facts so warrant. In this case, although the claim is monetary, the pleading that since the defendant is incurring heavy losses in the case of damages, my lord, some urgent interim relief may be sought by the plaintiff. Learned judge should have accepted this averment and allowed the plaintiff to institute the suit without section 12 pre-litigation requirement. Instead of that, he has tried to probe the nature, ambit, and merits of the claim, which at that stage was wholly unnecessary. But I had specifically relied on Yamini Manohar. But that was not accepted by our division bench, saying that it is just, you have to just contemplate, that's it. And Yamini Manohar was looked into and this was read. Though Yamini Manohar has not been mentioned, but my lord, this was made specific for a money suit, if your lordship kindly sees.
Yamini was placed before the division bench.
It was, my lord, but it was not taken into contention. Patil was taken into contention, my lord. My lord, Yamini Manohar is just an extension of Patil.
Yes.
And this was passed. So, according to the division bench of our court, my lord, only the pleading and which contemplates and it's not palpably false, 12A has to be allowed. The question of whether there can be any scope of any challenge to the 12A has been decided, but they have made an application for recalling and dismissal. So, my lord, I cannot stand in the way. They can make an application for dismissal all the time. And my lord, in their application, there is no scope of any falsity or anything of that sort. They are only saying, I have come after a delayed period from the cause of action. My lord, there can be a situation where the cause of action has arisen. I am within the limitation period. I find that they are not selling. Then they suddenly decide to sell.
Subsequent development.
What do I do? I will wait and get into further. Right at this moment.
If during pendency of the mediation, if such situation arises,
then we should approach the court. You are entitled to approach the court.
Pendency of
that suit is kept in abeyance.
No. Suppose take a situation first to apply before the mediation.
First.
For 12A.
Then we'll have to apply before the mediator to file a nil report immediately. And then come.
That's right. Non-starter has to be there.
Non-starter report and you have to come.
Because otherwise it might happen.
Yes.
During pendency of the mediation.
These are tactics which we as lawyers will always...
Then what will happen? What is the remedy?
Well, the remedy is either...
you have to apply before the mediator, the mediation fails.
And
give a non-starter report.
And then we'll have to come. By the time it goes, it goes. We enter into further protracted litigation. Like in this case, I would have been secure. If I had been on time, if I had not missed the bus, though I believe that there is a problem with them because I have found out that the sale was also illegally done.
And that's a difference.
So that I will come to that later. So therefore, my lord, I have also come before your lordship, my lord, with a prayer of security. That they have now sold it. They should secure my amount. They are not even getting... These are my submissions of 12A, my lord, and then, my lord...
The only judgment of division bench.
Only thing, my lord, I want to place from this judgment is, my lord, page 10.
Take microphone.
Page 10, if your lordship's take.
Judgment.
Of the judgment, my lord, of the Honorable Division Bench. The first paragraph, the top of the page.
Yes.
Once the plaintiff is allowed...
Page 10.
Page 10 of the judgment. Of the division, Honorable Division. Shrishti Infrastructure versus Sarga Hotel.
Unreported?
Yes, ma'am. Page 10. Page 10.
Kodak. Sure. Read which one?
Page 10 at the top.
Erroneous or malafide?
Yes. After that, once the plaintiff is allowed to file a suit without pre-litigation mediation, the discretion of the court should not be allowed to be interfered with at a later stage
otherwise it is likely to be dilated. Even after filing of the suit, the parties can be referred to mediation if the facts so warrant. My submission here, my lord, first of all, is that in this judgment, my lord, as your lordships have noted, the Yamini Manohar judgment has not been referred to. Now, the difference between, my lord, I have not read the partial automation yet, my lord, as of now. My lord, Yamini Manohar explains, my lord, what is the meaning of contemplation. That has not been considered here. Now, my lord, here the Honorable Division Bench says that even after the suit has been instituted with Section 12A leave, parties can be sent to mediation if the facts so warrant. Now, the facts here is, but from February 2025 at least, parties have been in discussions on how to, my lord, arrive at a settlement. Now, my lord, the situation is such that once the plaintiff has been informed that the property is being sold, thereafter, my lord, the parties will arrive at a settlement, and whatever amount is settled, the amount will be paid, perhaps. Now, my lord, in that view, I ask myself the question, can the plaintiff then short circuit the entire procedure and now take advantage of the fact that because the sale has been contemplated much prior, that now I'll come and secure my entire claim and my lord, not go into any mediation or any negotiation. Well,
And what about your selling of property?
Even that sale was contemplated to pay off the creditors.
No, but
in contemplation,
you have already sold.
Yes, because that was already contemplated. But as your lordships have seen, in February itself, it was informed that the sale has been delayed. So it is not the first time that the sale has been informed. It has been delayed. And the purpose of the sale has been to liquidate any dues that are there to arrive at settlement with the parties. As your lordships have seen, even a scheme of settlement has been proposed. So it is not that, my lord, the defendant is trying to shy away from its my lord, payments that it has to make. It is a matter of, my lord, settling the amount, because, my lord, we have shown in the opposition that there were certain disputes between the parties. Certain material was not up to the mark, and certain material has been returned. There had to be a settlement arrived at by reconciliation of the accounts. That is the endeavor they were trying to, my lord, carry out during the meetings. Now, my lord, the plaintiff had become smarter and tried to arm twist by filing this plaint and, my lord, short-circuiting the entire proceeding for mediation or for, my lord, settlement between the parties. So, my lord, my submission is that even at this stage, because the parties were already, my lord, negotiating, my lord, perhaps a mediation can be, even, my lord, at this stage, can be directed by our lordships, so that if the parties can come to a settlement, already, my lord, the property has been sold. It is not that they can, my lord, get an injunction of the property at this time. Property has been sold. Scheme is being considered. Now, my lord, my learned senior friend says that there is any fraud in the sale. My lord, I can assure your lordship there is no fraud in the sale. The entire my lord,
that's not to be looked into. Not to be looked into.
Submissions on 8 and 9 first.
Very well. These are your submissions. Judgment form হবে J2. ঠিক আছে? এটা কত? In re IAGA 3. IAGA com.
IAGA com 3 of
2025. ঠিক আছে? এই in re বলে। বোল্ড হবে তার নিচে। Facts. এইভাবে লিখবে facts, submissions, decisions. আমি বলে দেবো facts. আর প্যারাগ্রাফ সব কন্টিনিউয়াস হবে facts. The claim of the plaintiff arose. The claim of the plaintiff was for unpaid consideration, for unpaid consideration on account of goods sold and delivered by the plaintiff, singular defendant, by the plaintiff to the defendant. Full stop. আচ্ছা এর আগে একটা প্যারাগ্রাফ পড়ো। The instant application has been filed by the defendant for withdrawal and or cancelling and or revoking এই মাস্টার সামান্সটা কোথায়?
Notice of motion. Notice of motion.
The direction of the coordinate bench granting dispensation of requirement under section এই section থেকে bold 12 capital A of the এটা লিখে দাও Commercial Code Act যেভাবে লেখা আছে 2015 ব্র্যাকেটে for short বইটা দাও CC Act তারপরে প্যারাগ্রাফটা কি বলেছি বলো on the basis paragraph contemplating an urgency for an interim order, the petitioner, the plaintiff applied before this court seeking dispensation of the requirement of section 12A of the CC Act, being the pre-suit mediation procedure. Paragraph. The principal averments made by the plaintiff in support of such claim are quoted from the plaintiff herein below. Para 8. No, sorry. Para 10 to 14. To 14 from page 18 of the application. লেখো কোট 1 আমি এখানে লিখে দিচ্ছি কোট 1 এই যে বাবা এরকম দাগ দেওয়া কোট 1 এইখান থেকে 14 এ শেষ হচ্ছে দাগ এই যে কোট করবে মাঝখানে যেমন করে ইটালিক্স করে কোট করবে ছোট করে একটু ফন্টটা একটু বেশি না পোস্টার upon presentation of the plaint paragraph a coordinate bench by its order dated April 16 2025 inter alia, allowed the dispensation of requirement under section 12A of the CC Act. And the plaintiff was admitted. Mr. What's your name, sir?
Kanishk Kejriwal. Kanishk Kejriwal.
Niresh.
Kanishk. Kanishk.
Kanishk. Kanishk. Kanishk. Kejriwal. Learned Counsel, led by Mr. Shuddha Sattva Banerjee, Learned Counsel, appearing for the defendant. Referring to the averments made in the plaint, submits that the plaintiff has pleaded a case that goods were sold and delivered by the plaintiff to the defendant. And despite raising of invoices and demands, the defendant has failed and neglected to pay the due price of the goods. Despite? Failed. The defendant made part payments, and last of such part payment was made in the month of June 2024. During February 2024 to June 2024, the plaintiff supplied goods aggregating for a total sum of rupees 1,01,60,721. And the said entire sum is now due and payable, according to the plaintiff. The plaintiff then pleaded that in a meeting held on February 4, 2025, the defendant has expressed its desire and requirement of fund, as the defendant was passing through a severe financial crisis, and to meet such crisis, the defendant was trying to sell SELL, its plant situated at industrial area, Faridabad, bracket Faridabad property. The defendant has also informed the plaintiff that it has proposed to submit a scheme of compromise with the creditors under the Companies Act 2013, which would be filed before the jurisdictional NCLT for settlement of the dues of the creditors. Mr. Banerjee, the learned counsel for the defendant then submits that the plaintiff has pleaded that on March 20, 2025, has pleaded that March 20 now, pleaded that by an email dated March 24, 2025, the defendant further expressed its precarious financial condition and closure of its part of business. Poster. The scheme of arrangement with the creditor has already been instituted before the jurisdictional NCLT on March 7, 2025. And the defendant also forwarded a proposed scheme prepared by the defendant to the plaintiff. In the light of the above paragraph, the defendant submits that the cause of action of the plaintiff, as alleged, arose way back in June 2024. The moment the alleged default occurred on the part of the defendant has expressed its financial inability contemporaneously to the plaintiff, which is in or about June 2024 or so soon thereafter. The contemplation by the defendant to sell its Faridabad plant was also known to the plaintiff contemporaneously. Thus, according to Mr. Kejriwal, learned counsel appearing for the defendant, there was no sudden creation of urgency, and all such facts were known to the plaintiff much earlier. There was no sudden creation of urgency for an urgent interim relief as all such facts were known to the plaintiff much prior in point of time. First. Paragraph. Learned counsel Mr. Kejriwal then refers to the paragraphs from the plaint where the cause of action in the plaint has been pleaded and submits that since the cause of action has arisen much prior in point of time, the question for praying dispensation of the formality of the requirement under section 12 capital A of CC Act was not there. And as such, the said requirement should not have been dispensed with. Learned counsel for the defendant then placed Section 12 capital A of the CC Act and submits that the object of the said section clearly denotes a condition, mandatory condition precedent to avail of pre-suit mediation before instituting a suit, as in the instant case. By not availing of the said pre-suit mediation, the plaintiff has acted contrary to the provisions laid down under Section 12 capital A of the CC Act and thereby bypassed the mandatory statutory provision which is not permitted in law. In support, learned counsel has placed reliance upon a decision of the Honorable Supreme Court in the matter of Yamini Munahar versus such and such, reported at such and such. এটা দেখে দেখে লেখো, আমি কিভাবে লিখি শোনো। In the matter of, এইভাবে লিখি আমি, বুঝে নাও। বুঝে নাও তাহলে এটা একটু ভুল লিখেছে, বাট ঠিক আছে, উপায় ছিল না। এই যে এইভাবে ইটালিক্স বোল্ড হবে। ইন দ্য ম্যাটার অফ, লিখে নাও আগে, লিখে নাও, এইভাবে লিখে নাও। ইয়ামিনী ভার্সেস কি লিখেছো? ইয়ামিনী ভার্সেস কি রিপোর্টেড অ্যাক্ট, মাথায় দেখে নাও কি লেখা আছে। ও সরি সরি, দেখে লেখো, ইয়ামিনী ভার্সেস কি রিপোর্টেড অ্যাক্ট। First, learned paragraph, learned counsel for the your yes. Filed.
Yes, my lord. I'm deeply obliged, my lord.
When it was
My
filed?
lord, filed yesterday itself before 6 o'clock. And
Whatever.
Lordship's order was also uploaded very.
Yes, I uploaded and then I went to home.
I'm deeply obliged.
It was at 9 o'clock. কি বললো? Defendant then submits that on a plain reading of the plaint, it appears there was no urgency involved praying for an interim order. First paragraph. Accordingly, these are your submissions. The defendant prays for revocation of the leave granted by the court, dispensing with the requirement of Section 12 capital A of the CC Act. Paragraph. মিস্টার অনির্বাণ রে, শোনো এটা কি বলেছি জানো, কোথা থেকে ফার্স্ট শুরু করেছি? মিস্টার শুদ্ধ সত্য, লেড বাই শুদ্ধ সত্য, একদম ফার্স্ট প্যারাগ্রাফ। ওই তো কেজরিওয়াল বললাম, সাবমিশনের ফার্স্ট প্যারাগ্রাফ। Mr. Such and such Kejriwal, led by Mr. Shuddha Satya Banerjee. তাই না, শুরু করেছি ওর নামটা দিয়ে, মিস্টার কনিষ্ক কেজরিওয়াল, কনিষ্ক কেজরিওয়াল। ওটার মাথায় লেখো সাবমিশনস, আগেরটা ফ্যাক্স লিখেছো তো, ওটার মাথায় লেখো সাবমিশনস, ইটালিক্স বোল্ড, ফ্যাক্সটাও ইটালিক্স বোল্ড, একটু ফন্ট বাড়িয়ে কোলন, সাবমিশনস কোলন, আগেরটা ফ্যাক্স কোলন। এই দেখো এইভাবে লেখা হয় আমার। এই দেখো, এই দেখো ডিসিশন, ঠিক আছে, চলো পেয়ে যাবে, দরকার হলে এটা দেখে নিও কালকে সার্ভারে। কি বলুন? Mr. Anirban Ray, and a senior advocate, appearing for the plaintiff at the threshold, refers to the provisions laid down under Section 12 capital A of the CC Act and submits that the language of the section is very clear. That a suit, comma, which does not contemplate any urgent interim relief under the Act, comma, shall not be instituted unless the plaintiff exhausts the remedy of pre-litigation mediation in accordance pre-litigation mediation. Therefore, if the plaintiff contemplates an urgent interim relief, the mandate under Section 12 capital A can be dispensed with by the court upon being satisfaction recorded. Upon being its satisfaction recorded. ঠিক আছে, তুমি চলে যাও। এসো প্যারাগ্রাফ। Mr. Anirban Ray, learned senior advocate, paragraph, further submits that from a reading of the said provision, it appears the fate of the interim relief, the fate of the prayer for urgent interim relief shall not be a material consideration, or even the reliefs in the suit would have no bearing when the court shall consider, and the court shall only consider whether the contemplation of the plaintiff for urgent interim relief is needed in the plaint or not. Paragraph. Mr. Ray, learned senior counsel paragraph. Mr. Ray then submits that learned senior counsel Mr. Ray, then referring to the averments from the plaintiff, submits that the two emails that mentioning of two emails dated March 20 and March 24, 2025 in the plaint would show sufficient contemplation on the part of the plaintiff for seeking an urgent interim relief, for which the dispensation of requirement under Section 12 capital A of the CC Act was necessary. The point of time when the cause of action arose is not material. First. Paragraph. These are your submissions apart from the judgments. Huh? Mr. Ray then takes support from the decision of the Honorable Supreme Court in the matter of এইটা কিন্তু আমি যেভাবে লিখি কালকে লিখেছো বাবা অনেকবার in the matter of কোলন দিয়ে ওই বোল্ড ইটালিক করে ইয়ামিনী মনোহর সুপ্রা কি বললাম জামিনী দেখে লেখো দেখে লেখো না দেখে নাও ও লিখেছে তুমি জাস্ট লিখে রাখো এইভাবে তোমার তো ওইটুকু লিখতে হবে আর লিখতে হবে না ইয়ামিনী মনোহর সুপ্রা and submits the question whether a suit involves any urgent interim relief is to be determined solely on the basis of the pleadings and the relief sought by the plaintiff. If a plaintiff seeks any urgent interim relief, the suit cannot be dismissed on the ground that the plaintiff has not exhausted the pre-institution remedy of mediation as contemplated under Section 12 capital A of CC Act. Because of the cause of action in the plaint for final relief does not matter. Post. In support, the senior counsel has also placed reliance upon a decision of the Honorable Division Bench of this court in the matter of a Srishti Infrastructure versus Sarga Hotel, dated August 23, 2024, rendered in FMAT 222 of 2024. দেখো লিখে নাও। তুমি কালকে নিজেই লিখেছো, দেখো কিভাবে লিখেছো পড়ে নাও। ঠিক আছে, বলো। These are your submissions. Paragraph.
And well, this judgment specifies about a money suit and the contemplation of an urgent relief. That is what I want.
The moment money suit is contemplated specifically under the Commercial Court Act, in my view, subject to be corrected further in any other matter if it is argued that the strict principles that money suit injunction does not lie will not apply.
No, it doesn't apply anymore. After 2006, then 2008, there are sufficient judgments.
And that Tata Chemical matter we did. Yes, ki bolla?
That was a matter, well. Ultimately, my lord, what we were submitting, my lord, it was after. After, my lord.
Ki bolla? Hola. Paragraph. In the light of the above, Mr. HON'BLE and a senior advocate submits that this application is devoid of any merit and should be dismissed. এবার ডিসিশন যেভাবে কাল লিখেছো লেখো ডিসিশন। Decision. After considering the rival contentions of the parties and upon perusal of the materials on record,
Kindly, my lord, 2 minutes, my lord.
record, this court, comma দিয়ে, first proceed to read the averments made in the plaint, on the basis whereof the plaintiff claims dispensation of the requirement of pre-litigation mediation. The averments are already quoted above. The averments clearly show that admittedly to email, both one dated March 20 and the other one dated March 24, 2025, were addressed by the defendant to the plaintiff, informing that the Faridabad plant would be sold, and the defendant has applied before the appropriate authority seeking permission for this. The property would be sold to settle the creditor's claim, including that of the plaintiff. So to settle the creditor's claim. To to settle the claim. To settle the claim. Outstanding claims. The scheme for compromise with the creditor submitted by the defendant would appear from page 159 of the application, and specifically at page 171 it appears that as against the claim of the plaintiff to the tune of rupees 99,08,520, the proposed settled amount was rupees 19,81,704. Post 19,81,704. The plaintiff did not accept the said settled quantum. In any event, it is not the case of the defendant that nothing is due and payable to the plaintiff. The averments in the plaint at the highest shows, prima facie, that negotiation for settlement was going on for quite some time. Quite some time. Even if, full stop, even if it was within the knowledge of the plaintiff prior in point of time, than March 2024, that the defendant is in the process of selling its Faridabad plant, the confirmation ultimately came by way of writing through the said two emails dated March 20 and March 24, 2025, as pleaded in the plaint. Paragraph. The relevant portion paragraph from section 12A of CC Act is quoted below. 12A bracket 1 ঠিক এইভাবে এখান থেকে লিখবে, এইখান থেকে তুমি ওটা ইয়েতে পেয়ে যাবে, গুগলে পেয়ে যাবে, এই অবধি পুরো কোট করে দিয়ে বোল্ড করে ইটালিক্স first paragraph. On a meaningful and harmonious reading of the said provision, this court is of the view that if the plaintiff does not contemplate any urgent interim relief, then it is a mandatory requirement under the statute to go for a pre-litigation mediation, to avail of the remedy, to avail of the remedy of pre-litigation mediation, pre-litigation mediation. First. Therefore, if an urgent interim relief is contemplated by the plaintiff, there is no bar under this section that the plaintiff cannot under the section upon the plaintiff to file the necessary action, civil action, without exhausting the remedy of pre-litigation mediation. To ascertain whether an urgent interim relief has been contemplated by the plaintiff, the averments in the plaint to be taken as true and correct and to be read as sacrosanct. First paragraph. The averment in the instant plaint shows very specifically that by way of the said two emails, as referred to above, of March 2025, since the defendant has contemplated to sell its property and inform the plaintiff formally in writing, the same has given rise to the contemplation of the plaintiff for an urgent interim relief. And hence the plaintiff prayed for dispensation of the requirement for pre-litigation mediation as provided under section 12 capital A of the Act. First, the Honorable Supreme Court, paragraph, in the matter of Yamini Monohar Supra, had observed as under. Set out para 6, para 7, para 34, para 35, ঠিক আছে, বুঝতে পারবে তো? আমি সাইডে তাও লিখে দিচ্ছি 6, 7, কি বললাম, 34, 35, এই যে বাবা এইভাবে লিখে দিচ্ছি। The expression used, the expression, এবার italics করে লেখো, contemplate any interim relief, এটা italics করে bold করে দাও। The expression contemplate any urgent interim relief, small quoted মধ্যে, as used under section 12(1) of the commercial of the Act, shall qualify the plaintiff, if pleaded in the plaint, to pray for dispensation of the requirement for pre-litigation mediation and under section 12 capital A of the Act. Furthermore, the subsequent order dated May 6, 2025 shows that after dispensation of the pre-litigation of the process for pre-litigation mediation, though an interim order of injunction was passed against the defendant dated September 17, 2025. No. When the injunction?
April 16th,
Huh?
16th April 2025.
April 16, 2025, the order dated May 6, 2025 shows that the learned counsel for the defendant submitted that the defendant has already executed a registered deed on March 26, 2025. In respect of the subject immovable property. First. Paragraph. It matters little whether ultimately the plaintiff, would succeed on its prayer for injunction or with its suit on merit. What it matters is averments in the plaint to show a contemplation by the plaintiff for an urgent interim relief, which in the considered and firm view of this court is there in the plaint as it appears prima facie. Paragraph. In view of the foregoing reasons and discussions, this court is of the firm view that there is no reason whatsoever to recall the order dated September 17.
16th April.
16th April.
April 16, 2025, under which the coordinate bench has dispensed with the requirement for pre-litigation mediation in terms of Section 12 capital A of the Act. Paragraph. The instant application, paragraph. IA com number 3, এটা bold হয় আমার IA থেকে, of 2025 is devoid of any merit and stands dismissed, without any order as to cause.
One thing, my lord, your lordship has referred to 2 emails. My lord, one of them is 12th February, the other is 24th March. 24th March includes the minutes of a meeting of 20th March.
No, your 24th March.
24th March includes, my lord.
And 20th March.
20th March is the minutes of the meeting, my lord. I'm sorry, my lord. Page 158, my lord.
Oh, it should be 4th February.
12th February. 12th February.
Email is 12th February, my lord,
One
at
is 12
157.
At 157, my
12th
lord.
February.
12th February. And then 20.
তাহলে ওই 20th মার্চটাকে না কেটে করে দাও ফেব্রুয়ারি 12 2025 আর অন্যটা ঠিকই আছে মার্চ 24
Correct. Sorry, my lord. And my lord, but item number 8, my lord, the interim order may be extended as
when it is expiring
today, my lord.
today I will explain
And extend that, and then, my lord, whenever the matter is
এটা আলাদা হয়ে গেল you are there
Yes, my lord. Yes, my lord. Yes.
আর এটা কত নম্বর হলো
3, my lord.
just wait
My lord.
still 1 hour to go
My lord,
you
it
can
is
leave
3:30 today. That is why, my lord, I mentioned.
oh 3:30
That's why, my lord, I find your lordships.
oh
That is why I said, my lord. Otherwise, I wouldn't have
বেশি
waited.
বেশি মন দিয়ে কাজ করছিলাম আচ্ছা তাহলে ওটা এক্সটেন্ড করে দিতে হবে
Item number 8, my lord.
কি হ্যাঁ বোর্ডে দেখিয়ে দাও কত নম্বর
লিস্টে থাকছে তো
which one
item number 8 and 9 are together. In 8, my lord, the interim order is still there.
8 লেখো
G1.
it remains it will remain
This
in
is
the
for
list
kindly, my lord, very urgent, my lord. So
it will remain in the list but I'm simply extending
Yes,
the
sir, the
interim
interim
order লেখো Mr. Anirban Ray Learned Counsel appears for the
Plaintiff
Plaintiff
petitioner.
plaintiff oblique petitioner
Yes, yes.
no in that application
J1. my
It's
lord.
the same matter, my
Yes,
lord.
my plaintiff petitioner.
plaintiff oblique petitioner paragraph Mr.
Kanishk Kejriwal. K. Kejriwal.
Kanishk
Kejriwal.
Kejriwal, learned advocate, led by Mr. Shuddha Sattva Banerjee, learned counsel, appears for the defendant. Paragraph. এটা অর্ডারের শীটটা দাও আচ্ছা এইটা শুনে
কোনটা? The last one is 17th September, my lord.
আচ্ছা আর এইটাকে না ইয়ে করো এইটা গুছিয়ে ওদের কাছে পাঠাবে The interim order last extended on September 17, 2025, which is in existence till today, comma, November 7, 2025, stands further extended till January 30, 2025 at 6 or until further order, whichever is earlier. আর এটা লিস্টে থাকবে জানাল করছি না কিচ্ছু করছি না লিস্টে থাকবে
Very grateful. Very grateful.
It is there.
6-7. It's a connected matters, this, my lord.
Which one interim order is this? 6.
My lord, 2 is a small application which I was pressing, my lord.
No, they will retain in the list position. They will remain in the list.
Weekend number 6.
Mr. Mohit Gupta, learned counsel, appears for
The plaintiff.
plaintiff. Mr.
She's
I'm for the defendant number 1.
Miss MS.
Oritra Chakraborty.
Oritra Chakraborty, learned counsel, appears for the defendant.
Number 1 and
Mr. Defendant number 1. Paragraph, Mr.
Satvik Raut.
Satvik Raut. Spell out. S-A-T-T-I-K.
ROUT.
ROUT. Satvik Raut, learned advocate, appears for plaintiff defendant number 2. Show me the interim order. Last extended.
Last extended initially on 24th.
Forget about the initially. Last extended.
29th August 2025.
The interim order last extended on August
29th.
2025.
2025 is in existence till November 7, 2025, comma, today. Full stop. The same stands further extended till January 30, 2025,
26.
My lord, it is
20
more than a year they're enjoying the interim order.
2026, or until further order, whichever is earlier. Your applications remain.
Applications
It will be taken
will
up.
be there on Monday.
Lordship, item number 5, my lord, the interim.
Interim order expiring.
Today, my lord. It is expiring
I'm
today.
for the defendant.
Where were you?
Item number 5, my lord. It was.
Oh, it has not been called on. Who is the on the other side?
I'm
for the defendant.
J is appearing.
I'm for the
Mr. J is
defendant. I'm not
appearing for the
opposing,
defendant.
my lord. I will extend, my lord. And
Mr.
Obhirup Chatterjee, my lord.
Obhirup Chatterjee, learned advocate, appears for the plaintiff. Mr. Obhijit De, learned advocate, appears for the defendant. Number 124. The interim order last extended on September 8, 2025 is in existence till today, November 7, 2025. And the same stands further extended till January 30, 2025, 2026.
So the matter will remain in
It will appear, or until further order, whichever is earlier. It will remain
there
in
are
that.
other 2 applications filed by the
Sir, let us go through it, then we will see. কতটা হলো আজকে? কতটা হলো? ঠিক আছে, কালকে সোমবার দিনের লিস্টটা দেখো, সব যা যা রিটার্নেবল আছে সব দিয়ে দেবে। এই যেমন এরা করিয়ে নিল, তা না হলে বিপদে পড়ে যাবে লিটিগেন্ট।